being here. Of course, this hearing was begun this past Monday, October 27th at 2 p.m. We did recess or adjourn that day. It was stated that we go back on the record on Wednesday, October 29th at 9:30 a.m. Of course, we're beginning today at 2 p.m., and that's a result of the commission staff requesting for additional time to review the stipulation that had been filed between the parties and to see what additional questions needed to be addressed as a result of that stipulation. So let the record reflected that additional time was provided since the stipulation itself was filed on Tuesday, October 28th at approximately 1 p.m. I want to commend the parties for working out a stipulation that resolved many of the contentious issue in this case, and it kind of narrowed the issues left for us to address to those that are the parties who deemed that they were unable to resolve on their own. And with that stated, we'll go ahead and recognize counsel for the respective parties.
Good afternoon. Heather Fennell with the law firm of Brooks Pierce. Together with me today is Marcus Trathan with Brooks Pierce, Jimmy Irvin with Brooks Pierce. We also have Shannon Becker, the president of Aqua, North Carolina. And we have Kim Joyce, who is the vice president of regulatory and government affairs for Essential. Aqua. Thank you.
Thank you. We'll recognize Ms. Joyce for public staff.
For the public staff, appearing with me today are Lucy Edmondson, our chief counsel, William Freeman, James Bernier, somewhere in the room we have Ann Heworth, and perhaps Davia Newell. And we represent the public.
Thank you. Mr. Finley.
May it please the commission, my name is Edward Finley, appearing on behalf of the Brides Creek Property Owners Association.
Thank you. Are there any procedural issues that we need to address at this time?
If now's
Go ahead. Sure.
I'd like to move in our application and other preliminary matters, if that's okay.
Absolutely.
All right. I would like to move in the petition for approval of the Customer Assistant Program that was filed on March 27th, 2025 in this docket consisting of 15 pages. I would also like to move in the application of Aqua, North Carolina for a general rate increase consisting of 17 pages with 2 appendices, which was filed on April 30th, 2025. It also includes the application of Aqua Water and Sewer, which consists of 4 pages with 15 exhibits, which was filed on the same date. The application of Brookwood and LaGrange Water, which was 4 pages with 15 exhibits, also filed on the same date. The application of Fairways Water and Sewer, which was 4 pages and 15 exhibits, also filed on the same date. Also would like to move in the W-1 forms, some of which are confidential, which was filed on the same date. Then we also have the update to the W-1 form and a new Exhibit Q to the application, which was filed on May 13th, 2025. We have a second update to the W-1 forms, which was filed on May 15th, 2025. Then we have the update to Aqua's actual revenues and expenses and rate base and cost of capital for the period ending June 30th, 2025. Some of this was also confidential, and this was filed on August 18th, 2025. And then if it's okay, I'll move on to the stipulation.
Go ahead. Okay. Sure.
So then we also have the partial settlement agreement and stipulation of Aqua and Bright Creek consisting of 10 pages, and that was filed on October 22nd, 2025. And then we have Aqua and Public Staff agreement and stipulation of partial settlement, which consists of 14 pages and 1 exhibit, and that was filed on October 28th, 2025.
Okay. Without objection, we will admit into the record the petition for approval of Customer Assistance Program consisting of 15 pages filed on March 27th, 2025. Aqua, North Carolina's application for general rate increase consisting of 17 pages and 2 appendices filed on April 30th, 2025. Aqua Water and Sewer application consisting of 4 pages and 15 exhibits filed on April 30th, 2025. Brook and LaGrange Water application consisting of 4 pages and 15 exhibits filed on April 30th, 2025. Fairways water and sewer application consisting of 4 pages and 15 exhibits filed on April 30th, 2025. W-1 form, some of which is confidential, filed on April 30th, 2025. An update to the W-1 forms and new Exhibit Q to the application filed on May 13th, 2025. The second update to the W-1 forms filed on May 15th, 2025. The update to Aqua's actual revenues, expenses, rate base, and cost of capital for the period ending June 30th, some of which is confidential, filed on August 18th, 2025. The partial settlement agreement and stipulation between Aqua and Brights Creek, consisting of 10 pages, filed on October 22nd, 2025. Aqua and the public staff's agreement and stipulation of partial settlement consisting of 14 pages and 1 exhibit, filed on October 28th, 2025. And without objection, those are moved into the record.
And if it's allowed, I'd also like to move in the testimony of the waived witnesses. if
Sure,
they-
that would be appropriate at this time.
So I would like to move in at the appropriate time, the direct testimony of Dylan DeSantis, which is 74 pages with 1 exhibit and 1 appendix that was filed on April 30th, 2025 and corrected on October 23rd, 2025. I would also like to move in the rebuttal testimony of Dylan DeSantis consisting of 64 pages and 1 exhibit, which was filed on October 10th, 2025. And the settlement testimony, consisting of 64 pages and 1 exhibit. And the settlement testimony of Dylan DeSantis consisting of 8 pages and 1 exhibit, which was filed on October
28th.
28th, yeah, I think it's 28th, 2025.
Okay.
And then the witness summary of Dylan DeSantis' direct and rebuttal testimony, which was filed on October 23rd, 2025.
Okay, without objection, we will admit into the record for the excused witness, Mr. Dylan DeSantis, direct testimony consisting of 74 pages with 1 exhibit and 1 appendix, filed on April 30th, 2025, as corrected on 10/23/25. The rebuttal testimony of Dylan DeSantis, consisting of 64 pages and 1 exhibit, filed on October 10th, 2025. The settlement testimony of Dylan DeSantis, consisting of 8 pages and 1 exhibit, filed on October 28th, 2025. And the witness summary, filed on October 23rd, 2025. Without objection, they're moved into the record.
All right, one last waived witness, if that's.
Yes.
All right, I'd like to move in the direct and rebuttal testimony of John Spanos, the direct testimony of 18 pages and 2 exhibits with 1 appendix, which was filed on April 30th, 2025. And I would also like to move in the rebuttal testimony of John Spanos, consisting of 32 pages, which was filed on October 10th, 2025, and the witness summary of his direct and rebuttal testimony, which was filed on October 23rd, 2025.
All right, without objection, we'll admit into the record the direct testimony of John Spanos, consisting of 18 pages, 2 exhibits, and 1 appendix, filed on April 30th, 2025. The rebuttal testimony of John Spanos, consisting of 32 pages, filed on October 10th, 2025, and his witness summary consisting of, which included his direct and rebuttal testimony, filed on October 23rd, 2025. Without objection, though, they are admitted into the record. Mr. Finley?
Chair McKissick,
Yeah.
on October 24th, the commission issued an order granting the motion to excuse Bright Creek's POA witnesses. Your esteemed court reporter told me that I need to come in here today and ask that that testimony of Mr. Mays and Mr. Melton, consisting of 14 pages, be copied into the record as though given orally from the stand, and that the exhibits 1 through 4 be marked for identification as pre-marked in the filing and be admitted to evidence. And she also told me that I should say that it ought to be done at the appropriate time so that she can fit it into the transcript at the place she deems appropriate.
Thank you, Mr. Finley. Without objection, we'll admit the joint direct testimony of Calhoun Mays III and Bud Melton, consisting of 14 pages and 4 exhibits, filed on September 26, 2025. Go ahead, Ms. Yost.
you. The public staff would move for the admission into the record at the appropriate time, the pre-filed testimony and exhibits of its witnesses who have been excused. And I would like to begin with Ms. McCullough. I would move the pre-filed direct testimony of witness Roxy McCullough, consisting of 34 pages and one appendix, filed on September 26, 2025, be copied into the record as if given orally from stand. We further move that the 6 exhibits accompanying that testimony be identified as marked when filed. And finally, we move the summary of her testimony as filed on October 23rd, 2025, be copied into the record as if given orally from the stand.
Without objection, we'll admit it to the record, the direct testimony of Rosie McCullough consisting of 34 pages and 6 exhibits and one appendix filed on September 26, 2025, as well as the witness summary filed on October 23rd, 2025. Without objection, then read it into the record.
Thank you. Next, I would like to move Mr. Wilcott's testimony in. This is the pre-filed direct testimony of Thomas Wilcott, consisting of 34 pages and one appendix, filed on September 26, 2025. We would request that it be copied into the record as if given orally from the stand. We further move that the 4 exhibits accompanying that testimony be identified as marked when filed and entered into the record. Finally, we move the summary of his testimony filed on October 23rd, 2025, be copied into the record as if given orally from the stand.
Without objection, those testimonies are admitted into the record.
Thank you. The public staff next moves that the corrected pre-filed direct testimony of witness Michael Franklin, consisting of 37 pages and one appendix, filed on October 24th, 2025, be copied into the record as if given orally from the stand.
Okay.
We further move that the 2 exhibits to his initial direct testimony as filed on September 26, 2025, be identified as marked when filed and entered into the record. Finally, we move that the summary of his testimony filed on October 23rd, 2025, be copied into the record as if given orally from the stand.
Without objection, your motion is allowed.
Thank you.
Now, did we cover the direct testimony of Wilcat and his witness summary?
Yes. I
Okay.
believe so.
Okay, and the 4 exhibits and the 1 appendix, are they?
I believe I did.
Okay, just for purposes of clarity, we will include that as a part of your motion. As filed on, it looks like the date was September 26, 2025.
That's correct.
Okay.
Thank you. And then finally, the public staff moves that the corrected pre-filed direct testimony of witness Michael Gorman, consisting of 114 pages and one appendix, filed on October 24, 2025, be copied into the record as if given orally from the stand. We further move that the 19 exhibits to his initial direct testimony, filed on September 26, 2025, be identified as marked when filed and entered into the record. We move that the summary of his testimony, filed on October 23rd, 2025, be copied into the record as if given orally from the stand. And finally, we move that the joint settlement testimony of Maggie Ackenhausen and Brian Collins, consisting of 11 pages and appendices 1 and 2, be copied into the record as if given orally from the stand.
Without objection, your motion is allowed.
Thank you.
Okay, I think we're ready to begin testimony today.
Thank you. Aqua calls the witnesses Shannon V. Becker, Charlie Y. Baldwin, Dean R. Gearhart, and Lauren A. Raup Plummer to the stand.
Looks like one person will be at the table, or, oh, okay, 2 up front, that's fine. 2 up front and 2 behind. Are there placards with their names for the court reporter?
Yes, sorry. Right here.
All right, looks like everybody's settled. Could you put your, well, actually, I think we're going to affirm this panel. Do you solemnly affirm that the testimony you're about to provide shall be the truth, whole truth, and nothing but the truth?
I do.
I do.
I do.
I do.
Very good.
Thank you. Mr. Becker, good morning. Could you please state your name and your official address for the record?
Good morning. My name is Shannon Becker. I'm the president of Aqua, North Carolina. I work at 202 McKeenan Court Drive in Cary, North Carolina, 27511.
Did you cause to be filed 38 pages with 5 exhibits on April 30th, 2025?
I did.
Okay. Do you have any corrections to your testimony?
I do not.
If I asked you these questions that were filed in your pre-filed submission, would your answers be the same today?
They would.
Okay. Did you cause on this to be filed a summary in this proceeding?
I did.
Thank you. Mr. Baldwin, could you please state your name and your official address for the record?
My name is Charlie Y. Baldwin. Address is 202 McKinnon Court. That's in Cary, North Carolina.
Okay. Did you cause to be filed testimony consisting of 12 pages and 1 exhibit on April 30th, 2025, as corrected on October 23rd, 2025 in this proceeding?
Yes.
Do you have any corrections to your testimony at this time?
No.
If I asked you these questions that were in the pre-filed testimony today, would your answers be the same?
Yes, they would.
Did you cause to be filed a summary of your testimony in this proceeding?
Yes.
Thank you. Ms. Brock Plummer, can you please state your full name and your official address for the record?
Lauren Ashley Rout Plummer, 202 McKeenan Drive, Cary, North Carolina.
Okay. Did you cause to be filed testimony consisting of 16 pages with 2 exhibits on April 30th, 2025 to be filed in this docket?
Yes,
Okay. Do you have any corrections to your testimony?
I do not.
If I asked you the questions that were in this pre-filed testimony today, would your answers be the same?
They would.
Okay. Did you cause to be filed in this proceeding a summary of your testimony?
I did.
Okay, thank you. Mr. Gearhart, could you please state your name and your address for the record?
Yes, Dean R. Gearhart. My business address is 202 McKeenan Court in Cary, North Carolina.
Did you cause to be filed in this docket testimony consisting of 29 pages with 1 exhibit as filed on April 30th, 2025?
I did.
Okay. Do you have any corrections to your testimony?
I do not.
Okay. If I asked you the questions in this pre-filed testimony today, would your answers be the same?
Yes.
Did you cause to be filed in this proceeding a summary of your testimony?
Yes.
Thank you. I'm going to ask Mr. Becker the questions regarding your panel joint settlement testimony. Mr. Becker, did you and the other members of this panel cause to be filed joint settlement testimony consisting of 7 pages on October 28th, 2025?
Yes, we did.
Okay. If I asked, do you have any corrections to that testimony?
I do not. We do not.
If I asked you those questions today, would the answers be the same?
Yes, they would.
The panel is ready for cross-examination.
Okay, we'll recognize the public staff.
Thank you, Commissioner. Panel, my name is Will Freeman. I'm an attorney with the public staff on behalf of the using and consuming public. I would like to ask y'all some very narrow topics about ROE banding. I believe that was only in your testimony, Mr. Becker, but we're here to have a conversation. So y'all hop in and let me have your thoughts. After I'm completed, my colleagues will have questions for you. First, I'd like to talk about the law governing ROE banding. And in those 2 notebooks right beside you, Mr. Becker, if you'll turn to the tab 6. Are these identical? The bigger one.
I think we're going to testimony this evening.
And while he's presiding, Commissioner McKissick, I would propose to mark this. Should we mark it as Becker direct Public Staff Cross-Examination Exhibit 1.
That would be appropriate.
And tab 6 is the law governing the WISP, and also behind it is the session law. Have you found it?
Yes, I have.
And I'd just like to, I know it's a statute and we have it, but just for ease, you'll remember this law came from Senate Bill 211. Passed, it was signed by the governor in September of 2021, passed out of the House with 103-0 and the Senate 46-1. You can find that at pages 5 to 9. That's the session law. But if you'll look at page 2, subsection G of the law,
Okay, I found it.
and this, I think, is the section that talks about ROE banding, which is the topic I'm asking you about. And I read this law as entrusting the commission to use its judgment and discretion to surround the ROE with a band. And I read this law to say that band can be anywhere from 0 to 100 above and 0 to 100 below on either side of the agreed upon 9.8 ROE. Is that how you read this law?
I would agree.
So that's a 200-point spread, right? Maximum of 10.8, minimum of 8.8.
Based on the settlement ROE, yes.
Yeah, and public staff stands by the settlement. We're 100% in favor of the settlement. So from my point of view, those two bands are very different creatures. So I'd like to talk about them one at a time, if you don't mind. The first band, the upper band, which is subsection G1. And it says if Aqua exceeds the high end range of the band, whatever the commission sets it at, then Aqua must, quote, refund or credit earnings above the high end range to customers. Do you see where I am?
Yes.
Just for purposes of the record, can you identify the paragraph you're referring to with?
It's on page 2 of what we've now marked as Exhibit 1 at paragraph G, subparagraph G, subparagraph 1.
Thank you.
Which is kind of near the bottom of the page. So one of the things I did was ask Aqua what a basis point was worth, and I made Aqua's answer an exhibit. If you'll turn with me to Exhibit 10, and we're going to come back to 6. Keep your finger there too. And while he's turning, Commissioner, I would propose to mark Public Staff Potential Exhibit 10 as Becker Direct Public Staff Cross-Examination Exhibit 2.
So marked and identified.
And if you'll look with me at the 3rd page of Aqua's answer. Do you see where I am?
The table?
Yeah, absolutely.
Yes.
Okay. We said, what's the value of 1 basis point? And the 3rd page identifies the value as being more than $30,000 a year. And you'll see the first number is 61,223. Just so I know you know this, but just to be clear for the commission and Porter, Aqua has put the first year and WISP year 1 and the base year together. So that's why it's 61 instead of the other 2 being 30.
Because it's cumulative, right?
And so if I add up the total decrease over the whole period sought here, I get $130,781. That's 1 basis point over all the systems for the base year and WISP years 1, 2, and 3. Is that correct?
That's how I would interpret what you said, yes.
Okay. Now, we filed the settlement just yesterday. I want you to know that that number has obviously come down. And I've tried to do some rough math. Always a worry when you have a lawyer trying to do rough math. But I did talk to some accountants as well. We came up with about $110,000 after the agreed upon issues, assuming the public staff position. Let me be very clear then. Can we agree that the value of 1 basis point over Aqua's whole system, including the base year and WISP years 1, 2, and 3, is now less than 130,000 and more than 100,000?
At the end of, after all the investment at the end of rate year 3, I would generally agree with that.
Okay. Thank you. So when we're talking about this 100 basis points on the upper band, again, whole system, 3 years, base year, that 100 points represents potentially millions of dollars to Aqua, potentially, right?
I'm sorry, how many did you say?
Millions. 100,000 times 100 is 10 million, but it's probably going to be less than that as a practical matter.
Yeah, one thing I'd like to check is I didn't put this together. So I'm assuming that the math is correct here on that. I mean, if I extend the math, I would agree with you, but 1 basis point, is that correct? I'm asking Dean or Charlie. Does that sound accurate to you?
Check, I mean,
And I put every page of your answer into that exhibit 10.
So then following through, and if the math is accurate, then I would agree with you.
Okay, thank you. Okay, I'd now like to talk about a different, sort of related but different topic, which is the commission's banding from the last rate case. And I've marked the commission's order from Aqua's last rate case as Public Staff Potential Exhibit 2, which Presiding Commissioner McKissick, I would propose to mark as Becker Direct Public Staff Cross-Examination Exhibit 3.
So move.
And it's a long order, but if you'll turn with me quickly to Exhibit 2, page 13, item 22. And I know you remember all this, just a refresher. It's an open book test, so. And I'll just, while you're turning there, I read item 13 as to say in the last rate date. Well, I'll give you, I'm sorry, I don't mean to rush you.
Okay, so I'm sorry, tab 2, page
13. Number 22.
Okay, thank you.
I apologize. Would that help? You want this copy instead?
Oh, that's good. Just
Okay.
takes a little getting used to.
In the last rate case, the commission utilized a band of 50 basis points, and the band was 0 basis points above the authorized ROE and 50 basis points below the authorized ROE for rate years, for WISP rate years 1, 2, and 3. Is that your recollection of what the commission did in the last rate case?
That's a recollection of what we did in settlement negotiations in the last rate case, not
And I-
necessarily decided by the commission.
I apologize. And you're right. If you look at page 11, item 8J, you'll see it was a settlement. I'm just agreeing with you. So we'll agree that as part of the settlement, it was 0 above and 50 below.
Which is part of a give and take of a larger settlement. Yes, I
I
would agree.
And I was going to say it was a settlement, so I'm glad you reminded me of that. I do want to say that the commission discussed the settlement and sort of its impact. You'll remember one of the issues from that last rate case was we asked for a lower ROE because of the new WISP statute. And when the commission was discussing it, if you'll look with me at page 62, behind tab 2 still.
You say page 62?
I did. I apologize, Commissioner. I've got to get this thing closer.
That's fine.
Okay,
The next to last paragraph on page 62 that starts with witness Hinton. Do you see where I am?
I do.
In that here, I see that the commission is kind of discussing the upper and lower band. And with respect to the upper band being set at 0, the commission said, quote, that was, quote, much more favorable to the consumer than Aqua's proposed ROE bands, which extend 100 basis points above and below. You see where I am?
Yes, I do.
Okay. This ROE band that was set at 0 above as part of a settlement in the last rate case actually triggered and came into effect as we flowed through the last rate case. Isn't that correct?
We had a refund. Is that what you mean? We did issue one refund under one rate entity because it did over earn and the others did not. They were under.
Okay. So the company's request, as I understand it, is to have the upper band of the ROE set at 10.8%.
Based on the 9.8 settlement, yes.
Okay? That means that if the company over-earns, then everything between 9.8 and 10.8 will be retained by Aqua, and everything above 10.8 would be credited or refunded to the customer. Is that how you understand that agreement? That-
After the adjustments are applied, that's how it would be, it would work, yes.
So I kind of agree with the prior commission that said not that it was more fair, but that it was much more favorable to ratepayers to have a very low upper band of the ROE. So why does Aqua want 100 basis point?
Well, it goes both ways. The upper band is what we have to give back if we over-earn. The chances of over-earn are not strong. We don't regularly over-earn. So it's less likely to over-earn than it is to under-earn. The under-earning there's no recovery of a surcharge, right? That is, we get the right to come back in to do this all over again. So it's just an equity. If you go over too high, the cost to actually doing it and going through that, it seems like it's a reasonable range at 100 basis points.
And I'm not trying to browbeat you, but why not 10? Why not 30? It just, as you get higher away, those numbers get higher into the millions. And that's, ratepayers paying the monopoly.
Sure, and it's a balancing, right? This is one aspect of how rates are designed and how utilities, private investor-owned utilities would be able to recover their costs and make money on their investment. But on the other side of that, there's lag that is more regularly consistent, that the shareholders are basically giving free loans without interest or recovery of during all of the investment during that lag. So this happens to be one that might be a little bit over, but doesn't come near counterbalancing the lag impact of where the shareholder is not able to get the return on their funds.
Okay. And I didn't mean to cut off anyone else from the panel by just talking to Mr. Becker so much. I'm going to talk about the lower part of the ROE band now, unless anyone has any other thoughts. Okay. And I think you kind of already got to this. If we'll go back to the law, subsection G2.
Which tab was that?
It was 6. You don't have to go back there if you don't want to. I think we kind of went through this already. The lower band can be up to 100 below.
Correct.
If Aqua comes in below the lower band, Aqua may come in for another rate case. It doesn't have to. Is that how you understand the law works?
Yes.
So this kind of law seems to be a protection for Aqua. If it's under earning, it can come in and fix its rates and ask for higher ones. Is that how you kind of see the law generally?
I would not characterize it as a protection for Aqua. It's a customer protection. Being refunded the amount over our earnings, which is not regularly, it's not very common, right? If you look at all of our rate cases for the past, since I've been here in 2009, we are regularly under earning almost immediately after the rate case. Now, the multi-year rate plan helps. Our last ROE, consolidated ROE for the company is 7.5 at the end of 2024. And we don't look at these in part of our stipulation. We don't look at these by rate entity. If we looked at it by company, we are under earning, right? We might have a smaller rate entity that maybe a project got delayed, so it's not included. We're not earning on it. But the smaller rate entities are more affected, where we may actually over-earn, more likely to over-earn. So we're giving a surcharge back. But when you look at us globally as the state, we're actually under-earning, yet we're still giving money back to the customers in that one rate entity. So I would consider it a significant customer protection. And that's how it was developed when we talked about this in developing the statute.
Well, I guess I see what you're saying. And I think the lower part of the band is, when can the company come in? Why not whenever it wants? Anytime it earns 1 penny less than 9.8. Like that, why make it 100 basis points? Why not make it 0? Because it's at the company's option. I didn't understand your rationale for having a lower, 100 basis point lower band. Because that means you can earn 9%, but couldn't come in for a rate case. And, the public staff wants a strong and healthy financially stable utility. So why not say, and again, I kind of see the lower band as when can the company come in for a rate case? Why 8.8? Why not 9.8?
Well, these are expensive. These cases are expensive, and we're very cost conscious of, all these costs go into rates, right? We do not want to come in if I have 9.7 or 9.6. This prevents us, if we get a WISP approved, it prevents us from coming in earlier than that. We're having rates effective. So it allows us to reset the rates when we're actually outside that band. So having a wider band on the low end, there's protection where we're not just going to come in because we're down to 200 or 20 basis points or 30 basis points.
But that's totally your decision, it's not mandatory.
Well, that hasn't been tested yet. Where we are earning regularly below the approved ROE and below the banded ROE. And here we're coming in asking for rates to be effective after the end of our prior WISP.
I guess all that to say is, I see the lower portion of the ROE as when can the company exercise its discretion, and then the upper portion of the ROE as that's the refund mechanism as being, that's the one that the commission said a lower number is more favorable to the consumer. I would say, and this is my words, not no one else's, that a lower band is more favorable to the company. And I think you just discussed why you disagree with me, but in my mind, I don't really have a strong opinion about the lower band because it's kind of the company's decision.
Well, we've been under the lower band for a long time. We haven't come in because it doesn't make practical. I mean, this is a very large endeavor, right? It's an expensive endeavor.
Okay.
So we look at it, we make sure that we're coming in at a timing that's appropriate, but I would disagree. The upper band is a protection to the customer. The lower band, there's not much protection to us. We're going to come in probably because we're under earning anyway. If I'm within 20 basis points, 30 basis points, I'm not coming in.
Okay. I understand. If you'll give me 1 minute, I'm going to consult with my colleagues, and I know they have questions for you on other topics. All right, thank you, Mr. Becker. I don't have any more questions for you.
Okay, thank you.
Good afternoon, Mr. Becker. I'd like to talk about performance-based metrics for a moment. In your direct testimony, you made a proposal to modify 3 of the performance-based metrics, or PBMs, in this proceeding. Is that correct?
That is correct.
And one of those was the utilization of the SRF program?
Correct.
All right. And regarding that program, Aqua has proposed that the incentive and penalty be removed and that this metric simply be a tracking metric. Is that correct?
That is accurate, yes.
Okay. And I'd like you to turn to page 13 of your testimony. All right, and I'm at line 13.
Page 13, line 13.
I'm sorry, no, that's not quite right. Hold on just a moment. Page 21, line 13. Sorry about that.
Okay.
So there, you indicate that SWIA, which is the State Water Infrastructure Authority, has made some recent changes to limit state-funded awards. And those limits are 5 million per project and 10 million per applicant for the emerging contaminants PFAS fund. Is that correct?
That is correct.
All right. Would you agree, though, that that fund, the emerging contaminants PFAS fund, is just one out of a number of drinking water state revolving funds?
I would agree with that, yes.
And would you agree that funds are also available for meter replacement, main replacement, addition of wells?
So while I can answer these questions, I think I'm going to pass the baton to Ms. Route Plummer to answer that. She's much more involved with the area of the applications for funds.
Thank you.
Can you please repeat the question for me?
I was asking Mr. Becker if he agrees that in addition to the emerging contaminants PFAS fund, there are also funds available for meter replacements, main replacements, and the addition of wells.
There aren't separate funds for those. Those all fall under the general drinking water fund. So all of those projects, whether it's meters, water main replacement, other infrastructure work not related to emerging compounds, goes into one bucket of money.
But those are projects that
Are qualifying.
qualifying. Thank you. And in fact, Aqua has applied for funds for water main replacement. Is that correct?
That is correct.
All right. The next topic I'd like to address is reporting, and in specific, reporting on the company's efforts to reduce the high cost of water that Aqua purchases from the town of Pittsboro. If you could please turn to the public staff's potential cross-examination exhibit number 42.
I'm sorry, Ms. Joseph, is that tab 40?
It's in the second notebook.
Yeah.
Okay, I have it.
You'll give everybody a second to get to that second notebook to flip to that exhibit. It's 42.
It's the document behind tab 42.
Which page of 42 there?
The whole thing, I guess, you can turn to page 3.
Page 3? Okay, thank you.
All right, and Presiding Commissioner McKissick,
Sure.
I'd request that this exhibit be marked for identification as public staff or direct cross-examination exhibit 4.
So identified, Mark.
Thank you. Mr. Becker, do you agree that this is Aqua's most recent annual report on Pittsboro reporting filed on September 30th of 2025?
It appears to be the one that was recently filed, and I'm assuming the date is accurate. Yes.
Thank you. That is all on that topic. Let's move on to the customer assistance program. So the company proposed a customer assistance program in the sub 631 docket that would be funded with $75,000 of funds reallocated from miscellaneous.
Could you bring your microphone a little closer? Not everyone can hear you.
Sorry about that. I was asking Mr. Becker, is it correct that the company proposed a customer assistance program in docket number W-218 sub 631 that would be funded with $75,000 from reallocated funds from the miscellaneous revenues?
We did request that, yes.
And do you agree that if the $75,000 was not reallocated from miscellaneous revenues to the customer assistance program, it would offset the company's revenue requirement and thus reduce customers' rates?
I'm sorry, can you repeat that question?
Sure. Do you agree that if the $75,000 that the company is proposing to fund the CAP was not reallocated to that program, it would offset the company's revenue requirement and thus reduce customers' rates?
Those are non-regulatory revenues or antenna revenues typically that come in that do help reduce customer rates. So if we did not use that $75,000, yes, that would be accurate.
Are you aware that Duke Energy Carolinas, Duke Energy Progress, Piedmont Natural Gas, Enbridge, and Carolina Water Service, Inc. of North Carolina all use or are proposing to use the North Carolina Department of Health and Human Services data to identify eligible participants in their existing or proposed CAP programs?
I'm not specifically aware, no.
Subject to check.
Subject to check, yes.
And is it correct that Aqua is proposing to use Dollar Energy Fund to identify eligible participants for its proposed CAP program?
I don't think that's to identify eligible participants. It's to facilitate the processing of a customer assistance program. Identifying will be as people need it. And it hasn't happened yet, which is why this is promoted as a pilot program. They would not be going out and specifically identifying who would be eligible.
But customers would be applying to them, submitting applications.
Eligible, yeah, potentially eligible customers would be notified of the availability of this customer assistance program and would contact Dollar Energy or one of their entities to facilitate the application process to determine if they are eligible.
Thank you. Those are all my questions for Mr. Becker.
Okay.
I don't believe. Yeah. Okay, those are all of the public staff's questions for Mr. Becker.
All right.
I believe though that we have some additional questions for other members of this panel.
Okay. Would you like to go ahead and proceed? I guess they're relating to settlement.
No,
They're,
Presiding Chair, these are directed to Ms. Rob Plummer.
okay, go right ahead.
We kind of divided up witnesses and they don't exactly match.
I understand. Sure.
All right. Good afternoon, Ms. Rob Plummer, Lucy Edmondson from the public staff. Got a few questions for you. Your exhibit 1 to your testimony shows the 8 PFAS projects the company has put in place as of March 31, 2025, correct?
That is correct.
Have any more PFAS projects been completed since March 31st, 2025?
Yes.
And how many?
We're doing startups this week, so I'm doing an active number. 1 second. I'm currently at 41.
And how many, do you know how many are planned to go into service through the end of this year?
It will be 50 plus the original 8 for a total of 58 in service cumulative.
And so that's 49 complete and 9 to go for the rest of the year.
Yes, that's correct.
That was lawyer math, it worked. Do you have final costs for each of these completed projects yet?
The original 8 from last year, yes. The ones from the first half of this year, we are still receiving some invoices.
When do you expect those to be complete or to have received all the invoices?
We're hoping to have those complete by the end of next month for the ones completed in June.
So that's about a 5-month lag or so.
Yes, that's where we're at right now.
So the public staff has not received the final cost for these projects, and neither has Aqua at this point.
That is correct.
Moving to, let me ask you this. You mentioned at, let's see, in your testimony, when you're talking about interconnecting with other systems, you mentioned about them being PFAS free.
That is correct.
Is being PFAS free the standard required by the EPA?
For mitigating PFAS,
Yes.
being below the MCL. So we're looking at systems that are also below the MCL, which would not be out of compliance.
But that's not PFAS free, right? If you meet the compliance, there's some allowed. Is that correct?
We're looking to connect to compliant systems that do not have natural occurring, or, well, natural occurring is incorrect. I apologize.
If you could both speak a little louder, pull
Sure.
the mic to your closer.
So we're looking at systems whose raw water intakes do not include PFAS.
All right. And table one on page 6 of your testimony sets out the PFAS maximum contaminant levels and the health-based water concentration levels that the EPA has.
As promulgated.
Right. What's the difference in the expense to be PFAS-free versus meeting the MCL and HBWC standards? I mean, is there a significant difference in the cost?
HBWC.
I'm sorry, the health-based water concentration levels that are you list in your,
If I may answer, I think your question, PFAS free, if you're under 4 parts per trillion, you're effectively almost PFAS free. Our objective is to get to below that maximum contaminant level. I don't think there's a level of, and please correct me, but I don't think there's a level of filtration or treatment that's the next step to get, once you're at 4 parts per trillion or lower, there's not another level of filtration to go to another level of absolute zero. A lot of the testing cannot be seen below 4 parts per trillion, which is, I think, why they chose that initially. And I think the methodologies are progressing. But I think what the confusion is, below 4 parts per trillion is really effectively PFAS free.
I'm following. You're now asking about the hazard index, not the
Right,
MCL
right, sorry.
separate. No one's ever asked me about the hazard index. I apologize. So the hazard index piece, that includes multiple contaminants that don't have separate MCLs. The sites that we have identified, barring 6, it's all PFAS and PFOA in excess of 4 parts per trillion. They have not been identified on my list based off of their hazardous index calculation. They've either already had enough PFAS or PFOA to qualify as an MCL exceedance.
and would you change the media to reduce if the the levels were increasing? Would you change the media to stay in compliance?
We would certainly treat to stay in compliance. If you're exceeding the 4 parts per trillion, you would have breakthrough in the actual treatment media.
Let's go to page 8, line 9 of your direct testimony. You state that Aqua is investigating connecting affected systems to nearby PFAS-free water systems as an option to address the contaminants.
That is true.
Are you aware of any PFAS-free water systems near Aqua systems?
We have identified 2.
What are they?
2 rivers of Gastonia and City of Hickory have not reported PFAS in excess of MCL on their CCRs, their consumer confidence reports.
Are other water systems required to meet the same PFAS requirements as Aqua?
All public water systems are going to have to meet those requirements. That is correct.
Are there any water systems near Aqua systems that you have reason to believe will not be PFAS-free or compliant by the deadline?
There are several that are waiting litigation and other factors that may come into play. There are waivers that can be provided to systems that cannot achieve compliance by the actual compliance deadline that could impact Aqua customers should we be interconnected.
So you say that Aqua is investigating connecting to nearby systems. How is this investigation conducted?
We're identifying systems that do have adjacent or nearby other water supplies. So not all systems will be able to be treated just due to site footprint. We have several grandfathered systems that there is no well lot. It is just a wellhead that's at the end of a driveway. We would not be able to install treatment just due to site constraints. So those would be sites that we would have to look at alternative water supplies in general, just to stay compliant.
And What do you look at to identify those systems? Any particular records or?
Well, when looking at interconnecting, you need to look at all water quality parameters and compliance results. You know, we're mitigating PFAS, so we're looking for non-PFAS water. Mitigating PFAS with other PFAS doesn't really seem like a prudent investment choice. The other implications are there are other compliance samples, whether it's cryptosporidium or disinfection byproducts, things that you see in larger distribution systems that could also pose threats to our customers in terms of public health risk. There are also primary contaminants. So you would also be trading one primary contaminant concern for another primary contaminant concern.
So when you identify those systems, are you looking at DEQ records or?
Yes, in the consumer confidence reports that are made available.
Okay. And do you do that in-house?
We do.
And if you identify a system to connect to that you all think looks favorable, do y'all then contact that system to see if they'd be interested in interconnection?
So there are several phases in engineering, planning, and design. The first one is when we're doing a master plan, you identify all possible options on the table. So that is where we look to see who is close to an existing municipality or other non-Aqua system or Aqua system. And then we go from there. So the idea is you work your way through building an entire portfolio of options to find the prudent solution.
And then is there consideration about the distance between the Aqua system and the other system?
Certainly, an interconnect, we'd have to install piping, and it's roughly $165 per linear foot. So it doesn't take long to far exceed the cost of a modular treatment system.
But that calculation, you just gave us the average cost. That's something you all can do in-house. Is that right?
That is correct.
On page 10, line 19 of your testimony, you discuss Aqua's development of a modular treatment system design standard to address PFAS.
That is correct.
Do you know over what period that standard was developed?
It began in the summer of 2023 and concluded its initial design in April 2024 with the submittal of our first applications to Public Water Supplies Plan Review Unit.
And did you work on that project?
I did.
And you were an Aqua NC employee the whole time?
Yes.
Who else worked with you on the project?
We have answered that question in discovery. The other individuals were internal with Brian Harris, who's my filter technical specialist, Andrew Norris, who's an engineer too, Joseph Pierce, the chief of engineering and operations. And then we took our initial ideas and brought it to a third-party consultant who specializes in design plans, specifically for PFAS, which is Black and Beach.
And all of those employees or those people that you just mentioned, they were all Aqua NC employees during that period?
They were.
Are they all still employed by Aqua NC?
Everyone barring Joe Pierce at this time.
Joe Pierce is not currently employed by Aqua Net and C, but still with Aqua.
What entity with Aqua?
Aqua Services.
He's in Aqua
Aqua Services.
He was moved to a corporate position.
And Aqua Services, a certain amount of their costs are allocated to Aqua NC, is that correct?
Allocated or charged directly based on time, yes.
That is all I have. Thank you.
There are other questions from public staff?
Further questions for this?
All right, redirect.
Redirect. Miss Plummer, Do you recall at the beginning, Ms. Yost asked you some questions about the SRF fund?
I recall.
Yes. So even though Aqua has asked to have the incentives with that PBM changed, does Aqua intend to stop applying for SRF funds?
No, we intend to continue applying for SRF funds.
And in fact, you've been pretty successful in applying for those funds. Is that
That is
correct?
correct.
And that's reflected in both your testimony and in the reports you've been filing as part of the 573 WISPs going forward, correct?
That is correct.
Okay, thank you. Mr. Becker, do you recall Mr. Freeman asking you some questions about the banding?
Yes,
Okay, and so he thinks that each basis points is about $100,000. Is that correct? What we heard? Sorry, that's what I heard.
subject to check.
Subject to check. So, you know, I think by our math, it might be a little less than that. Do you recall we answered this in data request?
Yeah, and that's why I questioned it initially. It just seemed a little bit high, but I
It just
wasn't.
seems a little bit high. Okay, all right. And do we think that that is cumulative? Does that ring a bell? Or is that what you said earlier?
Well,
I-
a basis point impact in rate year one
Would be. okay.
equity is different than that by the time we got to rate year three as the investment increases. So it would be different.
Okay. Ms. Rout Plummer, one last question for you. We've been talking about interconnecting to municipalities for possible PFAS mitigation. Is that correct?
That is correct.
And this is, you were answering these questions that Ms. Edmondson has written or has asked you of that because you have actually done this evaluation, correct?
We have done the basis of this valuation, yes.
Yes. So when you are looking to mitigate PFAS for your entry points, you consider interconnection and you do an evaluation. And as Ms. Edmondson pointed out, a lot of this evaluation can be done in-house, but you have done an evaluation.
That is correct.
Yeah, that's all I have.
Okay. Well, we do have a few commission questions. And we'll go ahead and I think the first one here is to Mr. Becker. Could you tell us how Aqua chose the $75,000 annual budget for the cap?
Sure. Thank you, Presiding Chair McKissick. We have a director who runs all of our customer assistance programs where they're approved throughout the different states. So her name's Rita Black, and she helped us prepare the analysis that was requested from the last rate case. There was I can't remember if it was 11 or 13 additional bullet points that we needed to address. So she did the analysis to determine what the eligibility would be, as well as the expected utilization by eligible customers might be. And if 20% sticks in my head, so not all eligible customers actually request assistance. And based on her experience, from what I recall in her analysis, it was about 20% of the customers that were eligible actually utilized the assistance programs. So based on that, we actually thought of this as a pilot program to give us an opportunity to put it in place and gain some experience doing this without overfunding it and just getting the processes in place. So $75,000 was what she had estimated to be a good starting point to cover the initial years. And I'm assuming after we provide additional awareness and advertising of the program, that'll grow. So in future years, it may be higher.
Okay, and why is Aqua propose reallocating the antenna funds to fund the cap over other sources?
Sure. Antenna funds are non-regulatory revenues. They don't come from our customers. They come from third parties. They happen to utilize the assets on top of the elevated tanks. So we gain rents from third-party antenna providers. And I want to think, is it 200 and it's about $200,000 to $300,000 a year? Is that about right, Dean?
I think it's a little bit higher than that.
So we get several $100,000 of additional antenna revenues from those third parties. Doesn't come from customers. And as I was asked before, that money goes to reduce our revenue requirement because it's coming in from somebody else. So if we take $75,000 from there, theoretically or technically, it's not coming from the customer, but it does reduce their rates if we don't do it.
Okay. And what are the benefits of having Dollar Energy Fund administer the cap rather than keeping administration in-house?
Well, we thought about establishing a program like this in-house. You'd have to have somebody to be able to vet the eligibility. So we would need additional staff hired just to do this. Dollar Energy, from what I understand, is another program that we use in at least one, I think it's several other states, to manage the program. They determine the eligibility, they vet who is eligible, they send over the reporting, they track all the statistics. And additionally, Dollar Energy, from what I understand, if you need water assistance or utility bill assistance, you probably have other needs as well. They will connect their applicants who are eligible with other charitable organizations who might be able to help them in other areas. So it's kind of a larger benefit that's offered by Dollar Energy.
And on page 8 of the CAP petition, and I'll give you a minute to find that.
Okay, I have it.
Aqua states that a customer will need income verification and proposes to refer customers who have received a cutoff notice or been threatened with termination of services. Now, can you tell us exactly what a customer will need to provide in the application or with the application to be eligible for a grant?
I can't, I don't know the exact answer to that. When there is a customer who calls for assistance because they are unable to make a payment on their bill, we do offer payment arrangements, but when they're ready to get shut off, that means they've missed a payment arrangement or they've met certain thresholds where we need to move forward with collections. So we would refer them to the Dollar Energy Agency, and I do not know what the exact application looks like. One of the benefits that I understand is if those customers are already eligible for other assistance elsewhere, if they can provide validation that they're receiving assistance elsewhere, they would potentially be automatically eligible for additional assistance through this program.
Okay, and on page 10 of your testimony, and I'm going to address a question about the application fee. Why does the per applicant fee range from $9 to $15? What factors determine the final per applicant fee?
I actually do not know what the difference of the range is. I could find that out for you though. I asked that a long time ago, but I do not recall the exact answer. I don't want to misstate that.
Perhaps you can file a late file exhibit that would provide that information.
Sure.
Okay. And I think, Ms. Plummer, a couple of questions for you. Excuse me one second. Oh, okay. On page 14 of your testimony, you state that there are 138 capital projects for PFAS mitigation to be placed in service between January of 26 and December of 28. However, in table 3 on page 12 of your testimony, the sum of the projects for those years is 139. Do you know what the discrepancy is between what's stated as being 138 capital projects and likewise the sum of the projects in the table coming to 139?
It would be in 2026. I've had that number be both 81 and 82. It is currently 82, so 139 would be accurate.
139 would be the accurate figure. Thank you. We just wanted to resolve that discrepancy. Now, on page 13 of your testimony, it stated that the year 2026 is the high capacity year for PFAS mitigation project installation. What method does the company use to arrive at the estimate that 80 mitigation projects can be completed in that year?
So in my testimony, I talk about having the soft start and leading up. I did 7 last year that were the modular design. This year it's 50. Next year, with the existing capacity I have from my contractors, from the vendors for the vessels for treatment, from the enclosures that we're utilizing, 80 is the number we have settled on. They aren't all in one part of the state. They're spread out across the state. So I have different contractors for both sides, whether it's the western area towards Charlotte or the central to coastal area with Raleigh, Fayetteville, and Wilmington. So based off of resources, both internal and external with subcontractors, contractors, and actual vendors, we've arrived at 80 being or 82 being the top end of what can be achieved.
And you believe that realistically is achievable based upon information that is known to you today?
I still have 2.5 months left, and I can get probably another 30 this year if I wanted to, based off of what we've seen with our contractors and how fast they're able to install these treatment units. So
Okay. And on pages 7 through 12 of your testimony, you provide justification for the recommended modular, and I believe the pronunciation of that word is AON, is that correct?
anion.
Anion, okay. Exchange resin systems, including its listing as a best available technology pursuant to 40 CRF 141.62 subsection D and a small system compliance technology. Now, the small system compliance technology for PFAS includes reverse osmosis and nanofiltrification systems for systems serving between 3,301 and 10,000 persons. How many systems within Aqua, North Carolina's footprint will be eligible for that small systems compliant type of technologies?
So every one of our systems will fall in the small systems technologies category based off of the well design and the well treatment because they are groundwater systems. And ultimately, we went with the anion exchange based off our similar experiences with radionuclides, which also uses an anion. Well, uranium's anion, radium is cation, but it's both ion exchange technologies. It's just a chemistry switch between the two.
Okay, has the company considered reverse osmosis or nanofiltrification?
We have not, due to the brine solution, the concentrations that come off of it. It has a supernatant that comes out that's typically very concentrated and would have to be discharged. For this size system, that kind of permit is cost prohibitive.
So you think so essentially it would be cost prohibitive to either look at reverse osmosis or nanofiltrification
Due to the waste stream generated, yes.
through the waste stream generated. Okay. I think that covers the questions I had for you. I know that there are some questions that we would like to address to Mr. Herbert, but are we going to bring him? Apparently a text has been sent to me that I have not seen. So I'm going to rely upon Commissioner Comerwright and the text that she received to see if there are now any other questions from other commissioners. Commissioner Comerwright? Or Sheriff Brawley? Okay.
Good afternoon. Just a couple of questions. Mr. Becker, I think I'll start with you. So I think PFAS, I just have, I think just one question, and this is fairly general, but I'd like to have a better understanding about customers' expectations. And I know that customers have different perspectives, but can you provide the commission with some information about what customers, if you can generalize or provide any specificity about what they are expecting in regard to PFAS mitigation from Aqua?
It's a great question. Our customer experience with PFAS has been building for the last, 2006 years. We came out as a company and announced that we were going to do the right thing, get ahead of this when the rules were at 70, or the health advisory was 70 parts per trillion. And that's when the knowledge and the awareness really started getting out there with chemours. And in North Carolina, it was a hot spot. So I'll say the sensitivity with customers and the awareness by customers of PFAS and the impacts of PFAS has been much more significant than other states. It really varies. Some people are, who are aware and concerned with the environment and their water health. They're, they've dug into and wanted information about PFAS, and their expectation, almost 100% is absolute zero. Now, so basically they need to get to the lowest level, just remove it all from my water, regardless of the cost. And their understanding of the impact of the cost to rates is not always understood. I mean, they're not really part of what it actually takes to get there. We expect $80 million to be the cost to mitigate the PFAS in North Carolina. In our rate case, we've identified the number of units. We've also, I think within the last couple months, with the heightened testing, we have another 20 units coming. So people are very sensitive because they don't know where it is. And we've been helping DEQ understand where the testing is. We've been providing our sampling and sharing that information with them. So the folks are now realizing that it's not just in a certain concentrated area. It's not just on the coast, but it's everywhere. So their understanding that is this affect me? And if it does affect me, get rid of it as soon as you can. They don't want to wait 1, 2, 3, 4, 5 years. They call us. We do meetings with folks. We go out and meet customers directly when they have concerns, and they call in about the concerns. We started reporting the limits in our CCRs to help provide that awareness. But unfortunately, well, not unfortunately, one of the challenges you have when you provide all that awareness is people get a little more worried about, well, what are you doing about it, right? So what we're doing about it is we have our CIP plan to address PFAS by the time that it's required.
Yeah. Thank you. And then I'm going to move on to the customer assistance program. Can you just tell the commission, why did Aqua propose a customer assistance program, and why do you think it's important?
There are hardships that our customers go through just like everybody else. And, any opportunity that we can do that we can kind of centralize and help them pay for their bills or get through a short period of time where they can avoid shutoff, to avoid health issues or just a short crisis, we can be able to have utility service continued for their families. We think it's a good thing. Right now, what we're limited to is we have payment arrangements. So we do work with customers who have hardships, and we put them on a payment arrangement, but that doesn't help the short-term need where they're being threatened with a shutoff and they just can't make that payment.
And the funding, the $75,000 annual funding, is coming from the miscellaneous revenue. Can you explain to the commission why Aqua is not proposing any shareholder funds as part of the funding for the cap?
If we did that, that would typically be part of a larger settlement negotiation.
And then in your customer assistance program application, and you don't need to turn to it, it's on page 9, but you provide a description of the proposed cap benefits, and I'll just summarize some of the benefits that are mentioned in the application is reduction of unpaid account balances that lead to bad debt, and that's a cost that is passed on to all customers. Collection costs for the unpaid utility bills, which also would be paid for by all customers. Can you talk about, are you able to quantify, provide specificity? Because what I think what we're interested in is obviously a customer assistance program will benefit the participating low-income customers. But do you have any analysis about whether all customers, the non-participating customers, will they be held harmless, or would they benefit through reduction of bad debt, collection efforts, things like that? Has any analysis been done?
Not specific analysis where we've applied costs. We estimate very generically that a truck roll is about $50 to $60 for a customer to go up, for one of our operators to go out and turn off the water. And then we got to turn it back on. So if we were able to give that assistance, that would be avoided. Now, the base cost of that labor is still in rates, but we incur quite a bit of overtime as well. So you could assume that if we are able to avoid that cost by that operator having to go out and turn off a customer and then turn on a customer. They could be doing other things that would potentially avoid overtime. The collection costs are additional. But we have not exactly put a price, an actual savings per application together or something like that. The other thing is the bad debt costs would go down as well.
Okay.
Because we're not going to be collecting that customer's bad debt, or if they do go into bad debt, that gets written off into bad debt expense. Bad debt expense is part of the revenue requirement. So it should theoretically reduce the bad debt expense as well.
Okay. Thank you. And then I have just a couple of questions there, maybe directed at you also, Mr. Becker, about the performance-based metrics. And I am going to refer to the W-218 sub 573 order in which we approved Aqua's last multi-year rate plan. And in that order, if you'll recall, the settlement that was approved, the stipulation that was approved by the commission approved 17 PBMs, and then 14 of the 17 were tracking only. And so only 3 of the PBMs from the last rate case had incentives and penalties. And in this proceeding, Aqua is proposing that of those 3, that 2 of them be tracking only, which would lead to only 1 PBM being having incentives and penalties. And so before I ask the question, I'm going to quote from the commission's rule that implemented multi-year rate making. And Rule 117A states that the commission may approve penalties or incentives based upon the results of the approved metrics. So I'd like to get your perspective about, in light of the rule, is it appropriate for all of the PBMs except for 1 to be tracking only? What is your response to that?
The PBMs are established to accomplish various, motivations, whether it's a policy type item. I don't think that's up to me to determine the incentives, or I can make a recommendation as we did. But if the incentives and the penalties don't necessarily line up with what the effective operations might be, that's where we're going to make a recommendation to get rid of it. That's up to the discretion of the Utility Commission to add the incentives and the penalties. When we first came up with these, we don't have a lot of metrics that are established across all water utilities. So we identified these to start tracking them, to identify, okay, well, what is good? What is bad? In some of these things, when we're starting to look at, well, we've had 99.9% compliance. Well, that means you should, maybe there's an incentive to go to 100. It's very, very difficult to get there. Yet maybe the industry average is 95 or something less. So the incentives and the penalty, I think an incentive or a penalty should be if we're not meeting the standards, then maybe you continue to provide a penalty. If we're exceeding the standards, well, then maybe you acquire an incentive. One of the incentives we asked to be reduced was on the SRF, right? We're spending a lot of money submitting applications for funds that are going to be made 100% available to the customer to their benefit. I think we filled out $25 million in PFAS applications, and we've been awarded 15 million between grants. I think it's 13 million in grants and 1.5 or something like that in loans. And there is an incentive for that. And we're going to continue to do what's right. And there's also a penalty if you don't meet the certain minimum. Well, and again, we don't know what funds are going to be made available. So it's very hard for us to control that. Then if we have a limit, can we meet the minimum? So I don't think we're opposed to incentives and penalties that are justified and reasonable based on the intended outcome. With the completeness of capital, which is one of the ones that we said be removed and made a tracking, it doesn't take into consideration all the other capital and things that we're doing, the need for flexibility to be able to manage our program and projects. It's very static, right? So if something was said it was going to be done in 2024, gets done in January of 25, you miss the number. And it's not representative of efficient and effective operations. So we make recommendations, but no, I don't disagree that there should or shouldn't be any.
Okay. And then I just have a couple of questions about the PBM that you were just referring to, the timely completion of projects. And in the last rate case order, the sub 573, the commission provided some language in that order, and I'll just quote a few of the commission's statements. The commission recognizes that over the course of the MYRP, the relative priority of projects is likely to change, and some projects will inevitably be delayed. At the same time, others may need to be accelerated relative to the plan that as approved. And then the commission also stated that providing Aqua the flexibility to efficiently manage its business and provide adequate and reasonable quality of service without incurring a penalty on an individual project basis is a reasonable accommodation to the inherent uncertainty of creating capital plans. And the commission's language goes on from there. But under the current PBM, tell me from a practical standpoint, does Aqua have the ability to exchange projects within the plan without incurring a penalty within a particular rate year?
We do that. We must do that. I don't think trying to meet a metric at the expense of providing safe, reliable, and effective, cost-effective service should come into play. That's what we are going to do at all costs. And making those changes within a rate year from something that was in the plan to moving it to something that we need to do that wasn't in the plan shouldn't even be a decision. We're going to do what's right. But unfortunately, when we do that and we make those moves, the public staff would like to penalize us because we didn't do a 1-for-1, or we didn't exactly track it, or we didn't get it done at the exact time that it was said it was done, which is why we propose that additional PBM, which is more holistic and saying, well, let's look at all the projects that we did and not just say, well, this one wasn't done, so when are you going to do that one? And not necessarily pay attention to all the other ones that we took and did in its place. We either move forward or push back. We're making decisions all day or every day as to what the highest priority items need to be. And that's really one of the, my colleague over here, Lauren, that's one of her primary responsibilities as our engineering manager, working with our director of operations to do, is to manage the priorities of that every day and not necessarily incur costs to accomplish a targeted metric.
And then my last question about that, wouldn't it be an improvement from Aqua's perspective if the metric was revised to allow substitution of projects within the entire 3-year process? That would, I think that was in your testimony, that would be an improvement to you. And if there was still an incentive or penalty over the course of the 3-year period, would that still be an improvement for Aqua? If you could, and so my question is, if you could exchange projects, not by confined to a particular rate year, but you could exchange projects throughout the course of the 3-year period, and then there would still be an incentive or penalty. Would that still be an improvement over the current PBM?
I believe that would be the case. Ms. Plummer, would you like to expand upon that?
Yes, that was something that's come up in several of the reporting events between us and the public staff, was projects that were accelerated or delayed outside of the rate year they were originally declared for, and how they should be dealt with. If we did it early, should it count for the year it was completed or the year that it was originally supposed to be completed according to the plan? And if you finished it in a later year, how would you account for it? Because it's only looking at the snapshot of January to December of that particular year. It doesn't look at anything past that. It doesn't consider whether a project's in progress that is getting completed at a later date. And that was the bigger concern, is you're just capturing what was placed in service December 31st. If you missed it by 5 days and the contractor couldn't come out and turn a valve, I now don't get to count that project in January despite all the effort that happened in the prior year. So the flexibility is something that we were certainly interested in. I think there was a lot of understanding based off of our experiences in our first multi-year rate plan that has been addressed in how we've presented the CIP for the current application, that looks at that flexibility, that the like projects that have the same scope, the same purpose, are hoping to achieve the same end goal and how we want to package that to make more sense and address those flexibility needs, because it's not necessarily a contractor. It could be a permit or something that holds it up that's outside of Aqua's abilities to control.
And I'll just ask one last question just to make sure that I'm clear on the response. The public staff wants to, their position is they do not want this to be a tracking metric. They want to have an incentive and penalty. I understand Aqua's position about lack of flexibility. You need to be able to exchange projects or accelerate projects based upon emergencies or needs that come about. And so if there were to remain incentives and penalties for this metric, would it be an improvement to consider the net completion over the entire 3-year rate-making period, as opposed to having it be confined to completion of projects for the specific rate year 1, 2, and 3?
I think that's what our new metric that we proposed does, but it doesn't look at specific, where there are 200 projects and we did 198, but it was still, we spent more. The new metric kind of takes it holistically and takes a look at how effective are we actually being in, we're allowed to recover rates based on the capital plan that we provide. We've exceeded, through the end of this year, we expect to have spent $54 million or $50 million plus in capital, more than what was approved in the last CIP. Yet when you look at the metrics, the PBMs that are established, it looks like we failed many of them.
Mhm.
When you look at that metric isolated, yes, we have. But when you look at what we've accomplished, no, we've not.
But I guess, not to belabor this, but a difference would be that what you have proposed also is tracking only with no incentive or penalty, correct?
That is correct.
Okay, thank you.
Commissioner Tucker.
Thank you, Commissioner McKissick. Mr. Becker, I guess most of my questions will be for you. Ms. Plummer can jump in, or anybody on the panel can. I have a question about your CAP program.
Yes, sir.
Where is it that you've been told or shown that it is within regulatory law for you to put in place a CAP program and for us to approve it? Where is that in the law? I know you're not an attorney, but I mean, you're proposing something, you need to have legal backup for that. Share that with.
I think that's why we're requesting it, is if the commission approves it, then we would be fully supported with being able to effectuate it.
Again, the question is, where has your corporate staff or anyone shown you in regulatory law that a CAP, that you can have the opportunity to implement a CAP program?
I do not know that answer.
Right. I've never been, nobody's ever told me where it is in regulatory law that we can do that. Anyway, tell me what your CAP program would cost to assist the people that you have tracked and the numbers that you have. How much would the total program cost?
So that's within the $75,000 that we recommended for this pilot. It would be $75,000. It wouldn't exceed it. That $75,000 includes the costs as well as what we would provide for the assistance to eligible participants.
Okay, so I have trouble with pilots because pilots tend to grow in numbers. But that $75,000 would come out of your antenna revenue and not impact the ratepayers. Is that correct?
It would come out of antenna revenues, which is paid by a third party. But the way the revenue requirement works is the antenna revenues reduce the revenue requirement. So by taking the $75,000 from there, you would have $75,000 less coming from a third party that helps reduce the revenue requirement that determine the rates.
So the answer would be that if you implement a CAP program, it will in some way impact ratepayers.
It would, the way the rates are designed, yes.
Again, just dovetailing back to the question that Commissioner Kimright said, the other rate cases that I've been involved in, you may or may not be aware of, but I find you to be someone that's on top of things most of the time. They have used shareholders' monies to pay for CAP programs? Why did you choose not to? Your statement earlier, I think, was that it would be a elongated rate case if that were the request, or you would have submitted that. Is that correct?
No, from my understanding and awareness of the offering of those programs in other states, it's typically part of the settlement process. If we agree to use shareholder funds exclusively or sharing, that would be part of the settlement process, which is a give and take process of other things as well. I don't know if I answered your question.
Why wouldn't you use shareholder money if, you know, you've seen of recent that there's been some questions about the CAP program? Why wouldn't you just go ahead and use shareholder monies?
That just did not come up as an option during our settlement discussions.
Really? So the consuming public staff says charge ratepayers rather than take it out of non-regulated revenues that Aqua has. They would tell you to take it out of ratepayers rather than using either all antenna revenue or shareholder monies?
No,
Is that what they said?
I believe it's the public staff's position that they do not believe any of it should come out of customer funded CAP program. They do not agree with the customer funded CAP
Right.
program, which theoretically this is what this is, because that monies go to reduce the current revenue requirement. The discussion, when I said it didn't come out, we didn't have formal negotiations on a request to say, why doesn't the shareholder, they would like for 100% of it to be funded by the shareholder. It was a unilateral request. That's what that's in their testimony.
But as you move through the settlement process, it's okay whether you put a CAP program in or not. Is that a fair question?
Well, actually, we kept it on the docket because we wanted to make sure that the commission had an opportunity to make a decision on it. We had discussions, but the positions didn't move.
Okay, that's fair. Let me see, you received or have not received about 5.2 million in grants yet, is that correct?
We've been awarded, I think, we've been awarded about 11.3 million dollars in
Right.
grants. We have not received that yet. We've received, and then we've been awarded 3.7 in loan funds just for PFAS. And then there's a couple other lead service line applications. There's additional funds for that we've applied for.
Huh?
As what, there was another,
The lead
Well,
copper
oh,
one,
lead-
we have not yet received
You've stated,
reimbursement.
you pretty much stated where I'm going with this. So out of that $11 million, that will offset the cost of PFAS equipment, which in turn reduces the requirement you have for ratepayers to pay for the PFAS projects.
dollar for dollar, yes, sir.
Okay,
As well as settlement funds that we've received from our lawsuits that we've
Okay.
already received 8.3 or 8.4 million. As part of our agreement and settlement, we've agreed to put that onto our books as kayak for contributions in aid of construction, which offsets the capital for that. So
okay.
all in, we'll have $23 million by the time we receive the funds that will offset our costs to
Okay.
installing the treatment.
In between January 23 and 24, I don't know if I'm placing it in the correct year or not, but you had projected to spend 122 million in new capital projects, and in turn, you spent 136 million, according to your testimony on page 8. So the difference is $13,915,000. Of that, do you plan to recover that in this rate case?
Yes, sir.
Okay, so you're at the 13 million's an adder on this rate case because you
Well-
overspent on the other one?
Right, so
Or the-
we invested more than what was allowed in our last WISP for rate years 1, 2, and 3, and that's, by the time you get to 25, we're expecting to spend almost 50 million more than what was approved in rates in the last case. So that goes into the consideration of what our ask for this upcoming case.
How much money of low interest loans, like the 1.76% interest rate, have you borrowed to offset the PFAS capital cost?
Do you know how much we've already received?
We haven't received any.
You can,
Well, from
you can get
before.
back to me on that.
We had loans from, not necessarily PFAS, but we had loans from another project that we did on meters where we were awarded, federal or state funding, where we had some amount, that replaced our current debt costs. That was the savings.
Okay.
It wasn't significant, those couple $1 million.
All right, I read somewhere where, you stated that the public staff was not including the engineering fees in the PFAS mitigation, that their number was reduced and they did not include that. Why so much money? Are they not cookie cutter, or is it different $20,000 to $40,000 spread in engineering fees because of well design? What is that about, please?
I think Ms. Plummer will be able to answer that,
Okay.
yes.
Ms. Plum?
Yes, I would be happy to answer that question. So there's multiple factors that go in. Not every well site itself is the same. They're not all beautiful flat discs. I wish they were. I have some hanging off the side of mountains, and some at the end of driveways. So there's different limitations that I have to work with the sites. That's just the topography. I also have differing water quality issues, whether it's in the mountains or in Wake County or down in the coast. Some sites have iron and manganese that are going to occur. Iron and manganese will foul the ion exchange resin because it binds to the little resin beads. So that has to be removed. It also is an added benefit for the customers because they tend to not like the iron and manganese in their water just from a secondary contaminant standpoint. But it will foul the media and reduce the media life for the PFAS removal. So those are what we call the complex water quality projects. They have a different set of values outside of my PFAS modular unit. The PFAS modular unit as a whole has a range depending on the flow rate. Smaller vessels are cheaper because they use less of the media, and media is a cubic foot rate for how much the ion exchange resin is. The ones that are closer, like over 100 gallons a minute, those get 48-inch diameter vessels, which is really like double. So they'll be more expensive just because the media costs are more expensive. But that being said, I'm not having to do near as much in terms of building a full building. They're cute little concrete pads. I like them. They're little concrete pads that we can build. Basically, it's 30 days to cure, and then you build the unit on top of it. That works in all of the site instances except for the driveway where I can't put it in the middle of the driveway. But you'll have different needs. Some of my sites already have maxed out electrical, so I'll have to do electrical upgrades and pull permits for that just because there are heaters to keep it from freezing. And then I also have sites where the wellhead was 1960s era, so it's very tight space. I have to be able to go out to the facility and come back and connect into the piping. So we'll do they call it valve bank modification. They'll have to do valve bank modification. If it's a treed site, I have to do clearing and grubbing just so that I can build and do an active construction project. Like I said, I'd love for them to all be in a nice field because it's a lot easier, and a lot faster for
Get it
that.
now. You're telling me all the variables.
There are a lot, but we have taken, by having, this is the design, this is the valves and the pieces, I can do bulk purchasing of those pieces and parts, and have them in inventory. So I don't have a lot of one-offs, which is definitely helpful for both inventory and operations and maintenance in the long run.
Okay, two more questions and I'm done. Is that, construction engineering costs coming from the company Black and Veatch that you continue to use? Are they doing the design?
Yes, they're doing all the design permits and the application of the
Okay.
calculation packages that are getting submitted to public water, for the drinking water approvals.
Okay, I would expect there's a supply chain issue with PFAS equipment. I don't know that to be a fact, but there has been some discussions administration wise of changing that 4 parts per trillion to a lesser amount. Have y'all taken that into consideration of perhaps not purchasing the Cadillac of PFAS removal equipment or less that could possibly reduce the cost, which would reduce the rate of return for your company, which would in turn reduce the rate for the ratepayers? That's my final question.
So
If you're conjecture, then you can tell me that too.
no, well, to a certain extent, There are several manufacturers for every component of the modular design. We did not sole source any particular piece, just from a standpoint of managing supply chain. There are several resin manufacturers that provide comparable products. We did not go with the most expensive one, which was the Calgon res material, because that one is more expensive because it's Calgon. They like their name a lot. But we do have several manufacturers that are more cost effective in the long run for our systems. And right now we are being very conscious of the need and the demand. We had about a 3-week delay on the resin material, but we were able to navigate that and use a second manufacturer. So we've been able to manage that very well so far. Shannon?
Okay, we got it.
Commissioner Tucker, I just want, one of the questions you asked was about the change in the parts per trillion, right? So right now, the rule is that we hit 4 parts per trillion. I'm not aware of, again, different mitigate treatment that's going to bring it down to, if 20 is the new number, 17, which that's going to be hard to unwind. But if that were a different number, I think we still use the same media, we still have a very efficient designed modular unit that we would utilize.
Yeah, well, we have a chemist as a commissioner. I'll leave those questions up to him. Thank you, Commissioner McKissick.
Sure. We're going to take approximately a 5-minute break, maybe a little bit longer. We're going to come back in here at 3:55. We'll complete any commissioner questions at that time and proceed. I think some of these questions we have gotten into were more for rebuttal, but that's fine.
Okay.
We got them here now. Thank you very much. We will reconvene at 3:55. get started. We will continue with commissioner questions. Commissioner Brawley, do you have any questions this time? All right, it's been answered. Commissioner Vanderbar.
Yeah, I just have a few to Ms. Plummer.
Ms. Plumbers.
Thanks very much. How long does it take to put one of these systems in, these PFAS, PFOA systems?
Do you want from design to?
Yeah, from design to installation.
Right now, it's running about a year. Most of that is actually in the permitting phase. It takes about 6 months right now to go through Public Water Supplies Plan Review.
And the compliance date for this is when?
So as written, it is April 2029 is the date for in compliance with the MCL. It is April 2027 for completion of the initial monitoring, at which point any notices of violation for failing to monitor begin, and that's when the quarterly monitoring for exceedances of the MCL begin.
And so there's quarterly monitoring that starts in 2027, and then by 2029, for those facilities that have what, one exceedance a year? You
They
put in-
exceed on the running annual average.
Okay, so it's on an annual average based on the 4 samples that you grab.
The 4 quarterly samples, that is
And
correct.
who are you getting to do those tests?
The sampling lab we're using right now is predominantly enthalpy.
Uh-huh. So tell me about your ion exchange technology. I mean, what do you do with the ion exchange resin when it's spent?
So it is currently projected to last roughly 5 years
Mhm.
before needing to be replaced based off of mostly bench scale models.
Bench scale. You've never done it on a large scale?
We are part of the large scale.
So we're all ongoing?
That is correct. We've seen some column results looking at the white papers. There was pretty robust data that showed that 5.5. And it's that's the short chain that goes first, and that's true for all of the technologies available.
When you say short chain, saying you're not talking about PFOA, but PFAS. You're talking about Gen X and C6 type.
Subsets of the per and polyfluoroalkylated substances.
So what do you do with the resin when it's done?
So as of right now, we're planning on disposing of it at a appropriate landfill. How that actually plays out is dependent on what they do with RCRA. We're paying very close attention to the RCRA designation related to PFAS.
Because if it's hazardous, if they say that the spent resin is hazardous, you're going to have to take it to a hazardous landfill. Is that what you mean?
Similar to what you do with radionuclides resin.
But the resin's more expensive than, say, for example, activated carbon and most of those ion exchange guys, as I think you mentioned, they're going to be, I don't know how badly, but they're going to be hurt by any iron or manganese in your water. Is that right?
So it will foul the media over extended periods of time, specifically if it's over the SMCL for the secondary maximum contaminant level for iron and manganese. So that's why those systems we're looking at removing the iron and manganese over SMCL.
So you're going to have to add another control system like a green sand or some kind of.
That is correct.
And so how does that compare? How do those costs compare with just plain grain activated carbon?
Well, the activated carbon wouldn't be removing out the iron and manganese, which you would still be in excess of the SMCL.
But that's not a problem for the PFOA and PFAS. It'll take that out, right? Because that's part of the EPA document.
The empty bed contact time for the granular activated carbon is much, much longer. So you have to be in contact for a longer period, which results in much, much larger vessels. So you'd be looking at more like a 6-foot diameter vessel to achieve the same amount of appropriate contact for absorption that you would have related to
But the activated carbon's a lot cheaper. So how much, I'm just looking at what's the relative cost of going with activated carbon versus an ion exchange that is going to be more sensitive to iron and manganese than I think the activated carbon. And you're going to have to deal with the spent resin in ways that are going to be, you're not going to regenerate those ion exchange resins. Whereas the activated carbon, you just burn it. Right.
So the activated carbon also requires backwash to refluff the beds, which creates a backwash waste stream.
That's a very small stream. I'm talking about at the end of when they're spent.
Yes.
Right. It's easier to get rid of. I mean, I think it's easier to get rid of spent carbon than it is with these, and I don't know what you're gonna do with these resins, but
So it will still have the PFAS, and if the PFAS is considered hazardous, then it will still be in the same designation of landfill.
so what's the cost differential?
For the disposal,
Just
Um,
activated carbon versus ion exchange resin.
they end up being, because of the volume needed for the sites, it ends up being a much more costly site initial capital outlay for the building and the building permits. The utility enclosures that we use do not require building permits because they are utility enclosures and they're staying within a 10 by 12 foot.
So wait a minute, which is more expensive? I'm sorry, I missed.
Oh, the GAC ultimately would be more expensive for the initial installment because of the site construction and the permits that are associated with building
Really?
appropriately sized.
Even though you don't have any commercial size ion exchange installations right now.
I do
You
have a
do?
GAC, I have a GAC system.
You have a
for
GAC system.
TCE, not
But-
for
Right.
PFAS.
But you don't have an ion exchange system in the ground right now, commercial size.
No, I do have, I have 40, however many I said, 41 to
Oh,
this
okay,
year.
you just don't
Yeah.
know what the breakthrough time is gonna be yet.
The breakthrough time is the unknown based off of natural water chemistry versus manufactured lab grade groundwater chemistry.
So you have some time here, right? I mean, you could wait a couple more, 3, 4 years. You only need a year to actually put them in. Other technologies could develop
I am limited in terms of how many sites I can mitigate in a year.
in a year.
We
You mean
talked about
install?
the 80 for the install, regardless of the technology selected, the permitting, the contractor availability, which is a big one, and the general steel associated with the vessels that you're constructing, whether it's a GAC vessel or a ion exchange vessel, you're still fighting over the same commodities.
So how many sites? You got 40 now. How many more do you need? Total,
So right
think-
now, I'm at 214 or 15, 215,
And of those 40 are already installed?
48.
48 are already installed?
Yeah.
So you have not dealt with spent resin yet?
We have not for PFAS. We have dealt with spent resin for radionuclides
Sure.
previously.
Sure. But right now you're thinking you're not going to regenerate, you're going to landfill it.
There is not currently an NSF approved regeneration for drinking water standards. You're allowed to regenerate a resin and use it for an industrial process or another non-drinking water, non-potable process, but you cannot use regeneration currently for drinking water.
Okay, thanks very much.
And see, there any other commissioner questions? I just have one or two. And of course, right now you're looking at the PFAS mitigation. You have the 80 projects which you're looking at moving forward with. But the thing that does give me concern is the ability of which, if we look at the last CIP that was a part of the last WISC and look at your projected completion of projects and the ratios that occurred, it's concerning because as I recall, if you look at like rate year one, I think it was only 30, there was a 33% percentage there in terms of projects for completion and in service. And I believe it was 64% that we're looking at for rate year two. So if we look at those completion rates that occurred in the past CIP, I mean, do you believe that you can actually get all of this work done that you're proposing to get done?
So I'll take this. The standardization was a big part of that in a way that we didn't benefit from that in rate years 1 and 2 in the current plan. By standardizing, like I said, right now we have 2 contractors that have already installed roughly 30 of these apiece, or they'll have installed roughly 30 apiece by the end of the year. Which also limits change orders and other things that happen in the field, other variables, because they're used to installing this particular equipment at these sites. Ultimately, the path we've picked by going with this is the solution for a vast majority of the sites, and we have it based off of bands of flow rate, whether it's 15 gallons a minute to 30 gallons a minute, 30 gallons a minute to 50, 50 to 100, and so on, that lets us group like systems together and go from there. We also took out a lot of the automation and the bells and whistles that they look pretty, but from a functionality standpoint, pressure gauges are the way to go. So we've taken a lot of the pieces out that require extra connectivity to Wi-Fi systems and other remote pieces. These are very much plug and play. You run the water through it, and the operators overall have not shown many concerns related to operating them, which is at the end of the day important for us because we have to be able to operate what we install. And that would be another piece of reverse osmosis, is we don't currently have a reverse osmosis system installed, so we would have to do a complete set of training for operators to use that technology. But in general, what we've put together should very much be executable based off of the limits that we've identified in the supply chain and with contractor availability and general permitting.
But in your last capital investment plan, the thing that got built into rates
Mhm.
was what was projected to be pursued. And you got built into rates projects that never got built. I mean, 33% in year one, 64% in year two. So I'm trying to understand whether, looking at the plan that you have today, if it's realistic, if it's achievable, whether, the projected cost and is such that if this commission were to approve what you have put forth, it is something that we can have confidence it can actually be executed. And one thing Commissioner Comerite talked about was the establishment of PIMs. That might be linked to perhaps the completion rate of these various projects, or likewise a PIM dealing with the ability to keep it within a cost that's specified based upon what your CPI plan has proposed to us.
Sure. Commissioner, I think the percentages come from the PBM, which tracks projects over $200,000, not necessarily our global.
Sure.
And that's one of the challenges that we had spoken about earlier. When you look at just those initial $200,000 projects that were included in the WISP, that's why we need that to be a little more dynamic and flexible to be able to accomplish those projects. Through the whole WISP year one, we're going to spend over $54 million more than what was allowed and approved. Now, that's just holistic. But when you actually look at those specific $200,000 projects that were on the list for rate year one, that's right. We did 33% in the first year, and I think the second year was 68. So, but when you look at it cumulatively, by the end of the time for the whole WISP, we will have invested much more than what was actually authorized or allowed in the WISP or approved in the WISP plan. So, and that's why we talked about the PBM metric not necessarily being or properly recognizing effectiveness and efficiency of us doing what we need to do to provide safe and reliable water.
And that's not just like dollar investments, that's in service investments. So that's looking at installing, we replaced several stretches of pipe that we identified asbestos in down in the Brookwood rate entity. That was one of the projects that was a substitution. Asbestos is a primary contaminant of concern. We identified that pipe. We have abandoned it and provided new PVC pipe for the distribution system at that location. So those were at least two of the projects that we ended up substituting in for projects that were unable to be scheduled as planned in terms of being postponed. So several other parts in Brookwood, they have radium systems going in. They're also in my PFAS list. So we are doing one design effort to address both of those contaminants at the same time, but to also make sure that the equipment we're selecting for both radium and PFAS will actually work well together. They aren't going to be separately designed by different engineers. They're going to be designed to be a cohesive treatment unit for that system. So we deferred those projects to make sure that they would have a comprehensive solution for both water quality issues. So there's several pieces that went into that looking at it by a qualifying project number, it doesn't necessarily capture that, well, we still mitigated asbestos in Brookwood. So it's just kind of, that was where the flexibility and understanding that how do we deal with differing issues with permitting or whether it's local or state level, and how do we manage those timelines in general. So that's been a big piece.
If I can add, you had another question on the tail end about the, should there be an incentive or penalty on the cost of the projects? One of the challenges there, when we were doing the discussions with public staff, they don't believe that, or they don't agree that our estimates are appropriate. So if that estimate comes out lower, now we're held accountable to this lower estimate, but we were right in the first place, we're going to get penalized twice because we won't get recovery of the full estimate that we had taken. In this case here, we've been working with these assets for 6 years with the vendors, the suppliers, the experts, the engineers, to develop our understanding of what does it take to put these assets and infrastructure into place. And particularly, I'm talking about PFAS. And you asked, is that a reasonable plan? We do believe we can do 80 next year. And we tailored this out, as Lauren had mentioned, some of these things require a lot more advanced planning. Those more expensive units are on the back end because they do require more advanced planning. So our engineering team and our consultants have taken the time to go through and say, what can we do now? How can we measure this out so we can come up with a plan that meets the 4-quarter running annual average by the due date? So we think we can actually accommodate this. And then there's a little towards the tail end, if we have a little bit just before everything's due, we are identifying again, another 20 projects have been identified through our sampling. So we anticipate as we continue to sample, more is going to be added, and we're going to have to respond and get those things done. But we're ahead of the curve, I think, with being able to get things at a cost today. So we're saving money, we're avoiding the pressure of the cost, the pressure of competition on our suppliers, on the vendors being able to install these things. I feel really comfortable in making sure that we're doing what's right for the customer to get these projects installed in a time frame that is going to meet the due date.
And you indicated that there were an additional 20 projects that have been identified since you originally
I believe
submitted your application. I believe that's accurate based upon what I read.
Yeah, so now that we're doing the official initial compliance monitoring using the EPA methods that are required for the rule, there's a couple sites that we had data from 2018 when the methods hadn't really solidified yet. So they may have been on the cusp, but now that we have a tighter confidence interval related to what the lab's producing for the results, we're finding that they are in excess of the 4. Those are the sites that we're looking at. They're getting added into the master plan to figure out where they fit best. But as Shannon mentioned, as we go further into the plan, into the rate years 27, 28, those represent the more complex water quality pieces that they aren't PFAS only. That they need more than just the modular PFAS treatment box. They're going to need additional levels of installation and consideration, and they'll also be more complex to actually construct. So there's a lot of planning that went into when we schedule which group of sites based off of, I think Black and Veatch calls them design buckets. These are the ones that also get nitrate removal. These are the ones that also get iron and manganese. Nitrate also competes for the same resin sites on PFAS as PFAS, just because they're both removed with the anion exchange. But that all went into the plan that we presented in the CIP. And then the rest of the capital investment outside of PFAS is based off of what we're seeing from my linear contractors who do main replacement. And where that is, I think North Carolina's been pretty fortunate, at least Aqua's been fortunate. We haven't identified any lead pipe to date, knock on wood. I hope that continues. But that means that we're able to do these asbestos pipe replacements and focus on some other things that we're identifying that are, at end of serviceable life. So there's a more dynamic design to how we put this CIP together versus what was presented previously. And a lot of that is learning on my part. I wasn't directly involved with the preparation of the last CIP. So there's a little bit that's, how I view it with my experience having been a regulator before and my experience doing construction oversight prior to that and how that ultimately plays into running a utility.
And I believe I read only 6 projects had fallen out of the queue of what you were initially identified. Is that correct?
Yes, they were all PFHXS only. They had none of the other per and polyfluorinated fluoroalkylated compounds in them. They were just PFHXS. I have them on hold in the back should something happen in that the promulgation or the proposed rule revision not in fact occur. We have talked to Public Water Supplies, Compliance Services, Emerging Contaminants Group. They are moving forward with the rule as promulgated at this time. So we're keeping a close eye on that. With over 200 sites, there are other options. So I'm continuing to chip away at the list of PFAS entry points to help our customers while we wait to see what actually happens on that. I haven't run out of sites to work towards mitigating, unfortunately.
I believe when you come back on rebuttal, we'll get more into some of the cost aspects of what your CIP contains, particularly based upon testimony that's going to be provided by public staff. But I'm sure there's going to be a lot of inquiries about that. And specifically, if we sit back and look at, I mean, if you look at those projects that are over $200,000, which you've identified appropriately, it seems like 37.5% of those projects in rate year one and 50% of those projects in rate year two, based upon your prior capital investment plan, exceeded 110% of what was estimated. Is that a correct figure?
Go ahead.
So those numbers are based off of 2021 labor and materials projections. And between 2021 and today, we have seen end over end 10% and 15% labor and material increases, which were far beyond anything would have been forecast at that time in 2021. That is a major contribution to the change in cost estimates. I would say I'm seeing higher cost estimates from engineering consultants. I'm seeing higher cost estimates from contractors, from vendors, the cost of steel, the cost of wood. Everyone heard about how plywood was impossible to get a hold of and how expensive it was. All of those factors impacted where we were to complete the same work that, 5 years ago, maybe that project was $275,000. Today, it is closer to $450,000 to $500,000. And that's using the same vendors, we doing shopping around for cost estimates to bring that down the best we can. And that's just the current run rate on those materials, specifically steel and wood. Those have been notably increased.
And I'm going to go ahead and shift gears because I know we'll get into more of that on rebuttal. But Commissioner Tucker asked about the potential for using shareholder resources to pay for the cap. To what extent has that been fully evaluated by Aqua in light of what the recommendations are by public staff at this time?
We have not had real discussions with the public staff to agree to a number. That's not something we're offering up automatically. It's strictly shareholder funds. But that is something that could be discussed in settlement.
And it's my understanding that Aqua believes that a cap would be good to address the needs of customers who are facing financial hardship and difficulties.
Primarily, yes, and then there are savings as well. As I mentioned, I wasn't able to quantify, but the savings on truck rolls, collection costs, customer service, there would be an actual tangible savings as well as a reduction to the bad debt expense. Those customers would no longer go to bad debt, and that is what's currently in the revenue requirement.
And do you have any idea what that savings would be as it relates to truck rolls that you refer to?
Yeah.
Have you attempted to quantify that?
Just going from recollection, a few years ago, we did an analysis on the cost of a truck roll, and there's a salary that's covered already in rates. The savings would likely be on overtime that would be prevented because that individual would no longer need to do that truck roll. They could go do the other job that would have required overtime. We estimated it to be about $50 to $60, I believe, per truck roll. And but that's just a very loose estimate.
And have you done any projections as to what those savings would be based upon the $75,000 that has been that you guys have come up with in terms of a customer assistance program? And what does that translate into in terms of the number of potential customers experiencing financial hardships that, in terms of trips that would be prevented?
Sure, we did not quantify the actual savings that would account for, and that's partially why we recommend this as a pilot, to take a look. Let's gain that experience, let's see what the impact is, the increase in, or the savings in the actual truck rolls, we can quantify those. The number of customers assisted, we can quantify those, but we could actually then measure the impacts as we have this in place as a pilot program. And that's primarily why we're suggesting it as a pilot.
Do you believe you could file a late file exhibit that would attempt to do some of those projections or calculations?
With assumptions, yes, I probably could. Yes, I could.
Okay, very good. Let me look to my colleagues. Don't see any further questions, so now we will have an opportunity for questions on commissioner questions.
Just a couple from the public staff. First, Commissioner Kimmerer asked whether it was appropriate to have just one PBM with incentives or penalties, and that would be, you know, if Aqua's recommendations were put in place. And this was a question to you, Mr. Becker. I believe you responded regarding the SRF metric that the company's penalized if it doesn't meet the minimum. And it's unclear how much funding is going to be available. Is that correct?
I believe so, subject to check, yes.
I just want to clarify, would you agree that there's no penalty for not being awarded funds? The penalty rather is if the company does not apply for funding.
I believe that's the case.
Commissioner Kimmerer also referred to the commission's final order in the sub 573 rate case. And I believe this was a portion that was quoted in your testimony on pages 22 and 23, which stated that the commission acknowledged that providing Aqua, quote, the flexibility to efficiently manage its business and provide adequate and reasonable quality of service without incurring a penalty on an individual basis is a reasonable accommodation to the inherent uncertainty of creating capital plans. And it goes on. Would you agree that the public staff is not proposing a penalty on an individual project basis?
In my recollection of reviewing the public staff's testimony, I thought, and I'm not positive, that they were recommending a penalty or some parameter that was based on individual projects, or maybe it was a quantification of projects above or below a certain number. And the idea of the penalties, penalties and incentives on the SRF monies, or whatever it is, we're recommending a reduction of the incentive. And on the SRF monies, we had more or incentives awarded to us than we had penalties. So we're just looking at the penalties and the incentives to be appropriate to induce and accomplish what it is that we're driving to accomplish.
I apologize. I may not have been clear enough, but this was regarding the timely completion PBM.
Could you please repeat the question?
Yes. Would you agree that the public staff is not recommending that the company be penalized on an individual project basis for not completing projects within the planned rate year?
So you're stating individual one-to-one versus looking at the rate year's entirety list of projects?
Let me say this a different way. Would you agree that the penalty is based on the company's failure to complete qualifying projects within 10% in rate year 1, 20% in rate year 2, and 30% in rate year 3?
My understanding is that was the
For the
subject
prior WISP, yes.
573 WISP.
Right. That was the public staff's recommendation, and that is what is currently approved, correct? Not on an individual project basis. The company is not being penalized because it did not complete a single project on time. Would you agree with that?
I believe that is correct of what's in place for the prior WISP, yes.
But not for what was proposed in this file.
I'm sorry, I'm not.
The joint WISP
clear.
testimony does not state that from public staff.
All right, I think we're maybe talking past each other. Would you agree regarding that same commission order that, let me pull it up really quickly here. The commission stated regarding the timely completion metric in the sub 573 rate case that it's not persuaded by the company's arguments that it's difficult to implement projects on schedule and on budget in years in the future. And the commission stated that implementation of the capital plan during the MYRP period is a baseline expectation of the commission. Further, indeed, the public staff's proposed benchmarks give Aqua significant leeway in completing projects late due to unforeseen circumstances, which may be outside of Aqua's control. Do you agree that the commission indicated that in the last rate case order?
Was that in the order or the discussion? Could you have a reference that we could?
Sure,
look at
it's
that?
on page 117.
Can you put the actual document in front of the witnesses, please?
Sure.
Could you quote?
This was Becker, public staff Becker cross-examination exhibit number 2. Yeah,
Yeah, big
yes.
one.
It was behind tab 2. Correct.
Page.
Page 117 of 142.
So exhibit 2 was the potential cross exhibit number 10, right?
It was the potential cross exhibit number 2. Is that correct?
Okay, so that,
Yes.
I'm sorry, Michelle.
Yeah.
make sure, I mean, I can,
Timely
exhibit 2
completion.
was the cross exhibit.
We're looking under timely completion of projects. It's the first paragraph. It's the second sentence.
Tab 2 was exhibit 3.
Two. I guess, would you mind reading that sentence beginning the commission is not?
You want to take a shit?
Sure. The commission is not persuaded by these arguments. Implementation of the capital plan during the multi-year rate plan period is a baseline expectation of the commission. Indeed, the public staff's proposed benchmarks give Aqua significant leeway in completing projects late due to unforeseen circumstances which may be outside of Aqua's control.
Thank you. And this is the plan, the CIP was put together by Aqua, correct?
Yes.
All right, I don't have any further questions. Thank you.
Thank you. Keep that open for just a second. Okay, Commissioner Kimmerite and Commissioner McKissick asked several questions about the PBM, and we'll acknowledge that most of this is going to be examined on rebuttal, and we have a lot. But while we're looking at this quote, Ms. Rott-Plummer, sorry to pick on you. Can you start at the very, if you go further down on that page, you're going to look up 1, 2, 3, 4, look up 5 from the bottom. There's a "the" that starts on the very end of that sentence, 5 from the bottom. It says the commission adopts.
And
So
based
that's
on
about
that,
the net movement.
would you like me to read it?
You don't need to read it, but we're not, is it fair to say that there's a fundamental disagreement about how the timely completion PBM is interpreted between the Aqua and the company?
That is correct.
Does Aqua feel that how the public staff is interpreting this PBM, is it an accurate reflection of Aqua's ability to manage its system?
I started reading.
I
I apologize.
I'm sorry, is the way that the public staff interpreting the timely completion PBM, is it an accurate representation of how Aqua is operating its system?
It is not.
And so, subject to check, the 67% for year 2, the 33% from year 1, that is not something that Aqua believes is an accurate representation of their performance. Is that a fair statement?
That is correct.
So we'll leave that there for now. We'll get on that on rebuttal. Commissioner Tucker asked some questions as well about the cap. Do you recall, Mr. Becker, that he asked about why the company filed this application? Do you recall, subject to check, in this same document that Ms. Plummer has, that the commission directed Aqua to file the cap program?
Yes, I do.
Okay. One last question. Also, Commissioner Tucker asked a question about the SRF program and a little bit about the settlement proceeds for PFAS. I believe you mentioned this, but it is Aqua's intent to have a deferral, and all of those costs will be attributed to the ratepayer. Is that correct? All of that will be flowed back to the ratepayer.
100%.
That's it.
Very good. Well, I think we've come to a conclusion with this panel. Ms. Brunel, do you have any motions?
Yes, I need to move the testimony in.
Go right ahead.
So I would ask that the direct testimony of Shannon Becker, the direct testimony of Charlie Baldwin, the direct testimony of Dean Gearhart, the direct testimony of Lauren Rott Plummer, and their exhibits as pre-marked be moved into the record as if given orally from the stand.
Without objection, your motion is allowed.
And I would also move that the joint settlement testimony of Becker, Baldwin, Gearhart, and Rott Plummer be copied into the record as if given orally from the stand.
Without objection, your motion is allowed. And do we have any motions in the public staff relating to the exhibits that were tendered?
Yes, thank you. I move admission of public staff Becker cross-examination exhibits 1 through 4.
Without objection, your motion is allowed. With this panel, you're free to go back and be seated at this time. I'm sure we'll call you back on rebuttal, which will, in all probability, will be around midnight. I'm only kidding you. That'll be tomorrow morning.
Presiding Commissioner McKissick, Aqua would call Gregory Herbert.
You could place your left hand on the Bible and raise your right hand. Do you solemnly swear the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth?
I do.
All right, thank you.
Presiding Commissioner McKissick, we have discussed with public staff, and I believe they've agreed that we would bring Mr. Herbert on for both his direct and rebuttal. If that's okay with the commission, we'll
Yes.
proceed in that fashion.
That will be fine.
Good afternoon, Mr. Herbert. Would you please state your name and business address for the record?
Yeah, my name is Gregory R. Herbert. Business address is 300 Sterling Parkway, Suite 200, Mechanicsburg, Pennsylvania.
Did you cause to be filed in this proceeding direct testimony consisting of 12 pages and 1 appendix? And I don't think there were any exhibits.
Yes, the exhibits were included in the filing packet that I
You sponsored the exhibits to the application, correct?
Yes.
Okay, and they were not attached to your testimony.
No, right, correct.
Thank you. And do you have any corrections to your testimony? No. If I asked you the questions in the pre-filed submission today, would your answers be the same?
Yes.
Now, did you cause to be filed in the proceeding a summary of your testimony?
Yes.
And is that summary true and accurate to the best of your information?
Yes.
Okay, so I'm moving to the rebuttal testimony. Did you cause to be filed in this proceeding rebuttal testimony consisting of 13 pages with, again, no exhibits?
Correct. Yes.
Do you have any corrections to your testimony?
No.
If I asked you the questions from the pre-filed submission today, would your answers be the same?
Yes.
Did you cause to be filed in proceeding a summary of your rebuttal testimony?
Yes.
And is that summary true and accurate to the best of your information?
Yes.
Presiding Commissioner McKissick, I'd ask that Mr. Herbert's direct and rebuttal testimony be copied into the record at this time, treated as if given orally from the stand, and I guess there are no exhibits to be pre-marked.
Without objection, your motion is allowed.
And also ask that the pre-filed summary of his testimony be entered into the record.
Without objection, your motion is allowed.
The witness is available for, I believe it's commissioners' questions.
And I think we determined during our break there would not be a need for any questions of this witness at this time, so he may be excused.
Thank you.
That is the end of Aqua's direct case, and it's now on.
Very good. We'll go ahead and begin with the public staff. We'll see how far we get today. We'll look at a reasonable breaking point for testimony.
All right, the public staff calls Evan Hauser and Sashi Bata.
Put your left hand on the Bible and raise your right hand. Do you solemnly swear the testimony you're about to provide shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
I do.
Thank you.
Mr. Hauser, I'll begin with you. Could you please state your name, business address, and position for the record?
My name is Evan Hauser. My position is a public utilities engineer with the public staff, and my business address is 430 North Salisbury Street, Raleigh, North Carolina.
On September 26, 2025, did you prepare and cause to be filed in this docket testimony consisting of 47 pages, an Appendix A, and 14 exhibits?
Yes.
On October 23rd, 2025, did you prepare and cause to be filed in this docket a summary of your testimony?
Yes.
Do you have any changes or corrections to your testimony, summary, or exhibits?
No.
If you were asked the same questions today, would your answers be the same?
Yes.
Thank you. Ms. Bata, could you please state your name, business address, and position for the record?
My name is Sashi Bhatta. I'm an engineer with the public staff, a water and sewer transportation and telephone division. And my business address is 430 North Salisbury Street, Raleigh.
Thank you. On September 26, 2025, did you prepare and cause to be filed in this docket testimony consisting of 56 pages, an Appendix A, and 10 exhibits?
I did, correct.
And on October 23rd, 2025, did you prepare and cause to be filed in this docket a summary of your testimony?
Yes, I did.
On October 24th, 2025, did you prepare and cause to be filed in this docket corrected testimony consisting of 55 pages and an Appendix A?
Yes.
Do you have any further changes or corrections to your testimony, summary, or exhibits?
No, I do not.
And if you were asked those same questions today, would your answers be the same?
Yes.
All right. The witnesses are available for cross-examination and commission questions. Okay.
Good afternoon. I'm going to start with Mr. Hauser. Okay. So Mr. Hauser, do you have your testimony in front of you?
Sure.
So we're going to start with the secondary water quality report. It's on page 41. You discussed several recommendations, the secondary water quality report, and I believe Aqua has agreed to most of your recommendations. Did you have a chance to review Aqua's rebuttal testimony where it made additional recommendations?
You're looking at page, sorry, you're looking at page 79.
Yeah, so page 79, exactly. Page 79 of the WISP panel testimony, lines 5 through 13. They discussed two additional changes to the water quality report. Do you have a reaction to those additional revisions?
Yeah, first I'll talk about the first revision starting at line 5. We're fine with that. If the subdivision is served completely by purchased water, I think it's okay to exclude that from reporting related to secondary water quality concerns. Starting number 2 on line 9, the discussion that subdivisions which are evaluated to be included in the annual report be excluded based on it's the same criteria that public water supply uses for systems that it regulates. A couple concerns with that. Primarily being that the difference between a subdivision and a system is nuanced. The commission's order on reporting on the semi-annual secondary water quality concerns, it does say that it's by subdivision, and I believe this rebuttal testimony identifies that Aqua has 1,265 subdivisions. So my initial concern with utilizing the recommendation made by Aqua in rebuttal is that it may be overly exclusive, where you may have a system that has 15 connections, therefore it's regulated by DEQ. It could be comprised of 3 subdivisions with 5 customers each. Under Aqua's recommendation, that would be excluded from reporting, but it would be under the Safe Drinking Water Act reporting to DEQ. So I think this is something I think the public staff is open to evaluating and discussing. I think there's a lot of nuance there. One concern if you move from subdivision to system is that you may overrepresent systems that are larger based on the flat metric for reporting. So
to summarize, I hear you're okay with number 1. Number 2 is a lot of nuanced, but you're willing to talk about it. Is that a fair representation of your remarks?
I think we need to evaluate it
You need to
further
evaluate
before
it.
we say, yes, do it, no, don't. So
Thank you for that. The other topic that you cover in your testimony on page 42, you talk about the Pittsboro Purchase Water Report, which your Councilman Yost spoke a little bit about with our witnesses. Do you recall that?
yes.
Do you know the history of the Pittsboro? Do you know why the report was initially requested by the commission in the last order?
I think the report was settled to by the parties in sub 573.
Okay. Do you know the issue that the report was created to address?
I believe the report was initially required to report on the company's intention, or sorry, the company's efforts to reduce the price the customers had to pay to Pittsboro for the purchased water.
Okay. And why does there need to be a reduction in the price?
The price is substantially, it's a significant usage rate. It's quite high.
So Pittsboro is charging Aqua significantly more than it's charging its own customers. Is that accurate to say?
I think the standard for a lot of municipal systems is to charge outside rates. They're essentially double what they charge inside rates. And the price paid by Aqua and paid by its customers to Pittsboro is quite high.
Sorry.
Sorry about that.
So I saw you nodding your head, Ms. Bada. You're also familiar with the rates that
I
municipalities
do,
charge.
Pittsboro charges out-of-town rights to Aqua for this subdivision.
So turning to your testimony, sorry, around page 24. So we also discuss municipal interconnection. Oh, excuse me. We discussed municipal interconnection
Yes, ma'am.
of the water systems. This is something you have discussed in regards to the mitigation of PFAS, correct?
Correct.
Okay. So were you here when we talked with Ms. Route Plummer at the beginning with her direct that she has done an evaluation of the interconnection of the municipalities for the mitigation of PFAS?
The extent of her investigation was there existing water line of another system close by? Was the interconnection an option, alternative option? But she has selected to go with ion exchange when the interconnection option was presented.
You recommend that Aqua consider interconnecting these entry points by doing a cost benefit analysis. Is that correct?
That is correct.
Okay. What are all the costs that need to be considered if you're going to look at the cost benefit analysis?
Well, first of all, my question to Ms. Plummer was, for those interconnections available options, did you contact the municipality to make sure that they're going to provide and supply the water? The answer was, if the source of supply has PFAS, then that was not considered.
Okay. I hear you. Putting that aside, if there was going to be a cost benefit analysis, what are the factors that you think Aqua should take into account in doing that cost benefit analysis?
Well, first of all, finding out if the municipality or the interconnecting system is going to supply the water, That's the first step.
Okay.
If say yes, then assuming Aqua knows how far away the existing water line that they're planning to connect to is, and figure out what size line, if that's a feasibility. Aqua has done multiple interconnections, so they should have some estimates of how much it's gonna cost. So you don't really need to have to, I know Aqua's contention was that, oh, we need to have a consulting engineer to put this together. That is not what I was trying to say. If the interconnection option was there, at least figure out if the municipality is willing to connect to your system. And if so, then approximately how much would it cost? And would that be cheaper than installing the ion exchange PFAS treatments on site?
Okay. So part of your evaluation would include the cost of interconnecting.
Exactly.
That's what I'm hearing.
Yes.
Would you also want Aqua to consider the cost of the water that it eventually would need to purchase?
It's not exactly, I mean, when I mean interconnection, that's something that Aqua needs to evaluate. Yes.
Yes. Also, they would need to consider the future PFAS mitigation costs. Is that correct? That the municipality will pass along to Aqua, we assume.
Well, all the regulated water systems are required to meet the same PFAS standards that has been set. So I don't know how that's going to be incorporated when the municipalities do incorporate that removal system into their system.
Okay. So this is the point. How can Aqua evaluate? They can evaluate some of their costs, but are there some costs that it will be difficult for Aqua to evaluate, considering that municipalities tend to charge non-municipal service receivers more? Is it just that it's difficult, not that it can't be done?
It might not be exactly known, but there's lots of other 165 primary contaminants that are regulated. And all these municipalities, if they have those issues, then they have to remove them. So Aqua probably has an experience of if a municipality had to install a treatment for a certain contaminant, have they ever raised the rate just for that? So take a look at what has happened, because they have many systems that purchase water from a municipality.
I don't agree that that Aqua is that municipalities are generally charging Aqua more. If you look at page 2 of Hauser Exhibit 1, it includes the purchase rates for municipal water source, all of Aqua's purchase water rates in ANC water. There are only 3 purchase rates that exceed Aqua's current rate year 3 rates.
Okay, thank you. I was quoting Ms. Bada. Can the municipality charge Aqua more? And as we've seen with Pittsburgh, that has occurred.
They could, but
They could.
They could.
I mean,
current
Pittsburgh is just a system that probably has the highest rates in the state. And I don't know what the reasons are, but they do. And all other municipalities have a lot less usage rate.
Some do. Okay, moving on. Let's talk about the PFAS engineering costs. We had some costs about that before. On page 27 of your testimony, you talk about the cost of PFAS treatment systems. And on line 5 and 6 of page 27, I believe that's, you talk about the engineering and consulting costs and how they're higher.
Yes.
Okay. And then, sorry. We're going to turn to page 29. We're really talking about 2 buckets of costs, correct? We have it's the 1.6 million for engineering cost, and then the 600,000 with the master plan to analyze the 196 PFAS mitigation. We're on page 29, lines 6 through 13. Is that
Yes.
correct? And have you had a chance to read Ms. Rob Plummer's
Rebuttal?
Yeah.
Yes.
And she agrees to allocate these costs over do you accept that that is true?
Yes.
Okay, so to the extent you have 2 sort of buckets of concerns with your engineering costs, the engineering and then you have the estimates, correct?
Yes.
Do you accept that the engineering cost, at least with relation to these 2 costs, have been addressed by the company? Do you agree with that?
Correct. The public staff's recommended engineering cost that was allocated to these 6 specific projects that were installed at the end of 2024, as we recommended, Aqua has accepted.
Okay, great. So the other part is about the actual estimate for the individual cost, correct? And this is really illustrated in one of your exhibits. So if you turn to exhibit 6, I think it is. Yes, exhibit 6, your exhibit 6.
Yes.
This is how you basically show your work. This is how you show your math, right? How you come up with your estimate for the PFAS costs. Is that correct? So part of what this is doing is it's reallocating the engineering cost, correct? That's part of it. And then you also take what is the total actual spend in 2025 and you average the cost over these, so over these projects. Is that correct?
Yes.
Okay. Are these costs final as far as you know?
So let me explain how I got my average. I took the 6 PFAS treatment projects that Aqua placed into service in November and December of 2024, and the 10 projects that they placed into service in June, before June 30th, 2025. Those are the actual installations. Aqua had provided the cost for those, saying these are the projects in service, this is the cost incurred. So the information that was provided to me, I took the cost that was given for each of those projects and averaged them out of the 16 total, from the total 16 projects.
Okay. Will you accept that with several of these projects, as Ms. Plummer said earlier today, Aqua is still receiving invoices and these?
I understand that now, yes. That was not made clear when the utility plant in service was updated on August 15th of 2025.
So there's still rolling cost in. I think as your attorney, Ms. Evanson, noted, it maybe takes up to 5 months. We can talk about this further with our witnesses later, but as these projects come on, additional invoices, like most construction projects, the invoices come in later. So these may not be, or as we know now, are not the actual final cost. So that's one.
I'm going to say the 10 PFAS treatments that were installed in 2025, I do understand there may be a few more invoices coming in.
Yes.
So those projects costs might not be final that I considered.
Okay.
But the 6 projects that were installed at the end of 2024, those are pretty much Aqua has agreed with, those are the final cost.
Okay.
So what I did to come up with that average was I had the estimates that Aqua had provided for those 6 projects and the actual cost that they incurred. Their estimates versus what was actually spent on those projects for those at least 6 are approximately 50% higher.
And as Ms. Rout Plummer will get into some questions with the estimates and inflation, but these are not final costs, but also, do you know that all of these projects are representative of all of the PFAS projects that Aqua will do? Are these typical projects? Do you know that these are typical? Do you expect all of the, what I think we're at 196 now, are going to be identical?
They're not going to be identical. I do know that there's a flow variation from, it depends on how much flow. I mean, that determines the capacity of the vessels and the type of amount of media that you need to put in. But I have seen, even between the ones that they have installed, I have seen the flow variations. There are different ranges of flows. And I have also seen some complexity with them, because I don't remember the exact names of which treatment they are, but some of them already do have some other types of treatments already in them, and they have incorporated the PFAS treatment. But I don't know the details of every entry point that Aqua needs to address.
So it would be fair to say that there's going to be variation in the complexity of the PFAS projects?
Potentially.
Potentially. Okay, that's it. Thank you, guys. That's it. Oh, okay.
Before we do that, may I raise a housekeeping matter?
Sure.
I failed to, I skipped a step and did not move the direct testimonies of Ms. Vada and Ms. Hauser. May I do that now?
Yes.
Thank you. I'd move the direct testimonies of Ms. Vada and Mr. Hauser, the corrected testimony of Ms. Vada, and the witnesses' summaries be copied into the record as if given orally from the stand at the appropriate time, and that their appendices and exhibits be identified as marked when filed.
Without objection, your motion is allowed. I was concerned about how far we would go this afternoon, but I think this is a good breaking point. It's 5 p.m. So we will adjourn for today. We will reconvene at 9:30 a.m. with the intent of concluding this proceeding in its entirety tomorrow. Okay? All right. Thank you.